My lord, an important item, my lord, may be kindly listed on Friday or Tuesday.
A matter regarding what?
My lord, this is regarding CRP.
No. Why importance in new matter?
My lord, there was the order of stay was granted long back. Case was not listed for last 3-4 months. There is the urgency, my lord.
Matter of which year?
This is the 23. 23, my lord.
23. Now you are for whom? Petitioner.
I am for the petitioner.
You have a stay order. Why are you worried?
My lord, let the case be listed only, my lord.
No. Listing by mention memo there has to be some exceptional reasons. You have a
Reason
stay
is
order in your favor.
reason is that, my lord, that it was stay order was returnable only for 3 weeks. So the lower court is giving trouble to the client.
Okay.
Wait, please, for these two matters, just to release of the amount deposited by the insurance company. The matter relates to release of the amount deposited by the insurance
Okay.
company. Matter may be listed on Friday.
You file application.
Lordship.
Okay.
Item number 1.
Yes.
Regarding LA case. Same LA case, your lordship appeared in another case, my lord. It's from
It is not.
IIT Guwahati.
This court will not appear in a LA case. This court will appear in some appeal. It's not. Appeal is on a different footing. Revision on a different footing. We have seen the records. It originates from the same LA case.
Yeah.
If there is commonality in the cause of action, we will not take up. Otherwise, we don't find that matter is connected. Is it connected with the earlier matter? Not connected. Well, how is it
Not
connected?
connected,
Parties are
matter.
different.
But the same LA case.
The origin is the same. The cause of action is different. Parties are different.
Then matter may be passport for the time being, my
No, we'll have it on Friday. Don't worry. We'll accommodate you. Friday we'll have.
yes.
Okay. And Friday, if we have some difficulty, then we'll recuse from the matter. Otherwise, we know this. There is some connected matter, but it's a different party, different appeal, different revision. Okay.
Maybe Friday, my lord.
On Friday. Item number 1 on the request of Sri A.K. Datta, Learned Counsel for the petitioner list on Friday.
Obliged.
Okay.
The concern of others that I beg to for item number 16. We
1
have
6.
put our respondent.
1 6.
We need some time, though. Because still we have entered a period.
18 matter.
Lordship, but they have without serving the copy, they have filed this appeal. And only on the
No, this appeal was filed long time in 18.
yes, Lordship, but on appeal we have entered a period because they have not served the copy and we have not received, but only on perusal of the cause list.
Were steps taken?
Steps are taken.
Then
But Lordship,
they are not obliged to serve copy upon you. They'll take steps as per court's order.
but Lordship, in this High Court standing counsel is here regarding the
Nonetheless, court, can you take advantage of the court's wrong? Court had directed him to take steps. He took
but
steps in
they-
18.
they not complete, but
Steps
they-
not complete.
We have one perusal of the cause list. We come to know that some cases filed against Oil India Limited.
That's those services yet to be, the report of the services yet to be returned.
Yes,
When have you entered appearance?
April. Yeah, maybe 11/4.
Okay, when do you want? 11/4, today is what? Today is 19/6.
After
18 matter, embarrassing. Sri K. Kolita Learned Counsel submits that they have recently entered appearance on behalf of the sole respondent and accordingly prays for time. Para, considering that this appeal is of the year 2018, list immediately after the summer vacation. Yes.
Obliged. May I please, your lordship.
Is there any interim order? No.
May I please, your lordship. I beg to mention for listing. So matter may become a
What matter?
testamentary case.
Testamentary appeal
My lord.
or case?
Appeal file. Already matter was fixed on 13, but the earlier occasion
Will it come before this bench or the other one?
is when
Mary? Chandan? Huh? No, এটা বদলাইছে নহয় অকল ফার্স্ট এপিল দিছে আমাক ফার্স্ট এপিল আৰু ৰিভিজন দিছে সেকেন্ড এপিল দিয়া নাই টেষ্টামেণ্টাৰী কি টেষ্টামেণ্টাৰী আছে Okay, when, matter which
Yeah.
year?
20.
20?
Two-
Okay,
Public.
when do you want?
25th,
Next month, next week?
my lord.
Next week is not be possible. Next week is the last
Ah,
week.
Earlier occasion, several times was speak, other side, they
25th,
have
nothing,
taken
nothing
time.
would be done because next week will be a motion day. As you know,
Then 26th,
next week is a motion day. 24th to 28th. You have it immediately after the vacation
my lord, date may be
on 15th.
applied,
Okay, 15th of July
applied,
is the reopening day. Be ready on reopening. Okay.
applied.
Yes.
May I please, Your Lordship, with concern with the other side, I recommend item number 12. Lordship.
Item number
12. Lordship.
12. Yes. Yes. What is your prayer?
Lordship, this matter may come up on Monday, Lordship, next week.
Year for whom?
Lordship, I am for the petitioner. Lordship.
Other side informed. Guwahati
Yes, sir.
University, Monday? Okay. On a prayer made on behalf of the appellant. List on Monday next date, huh? Okay. Item 2.
Division is a order passed by trial court, rejecting my petition for passing decree on admission matter. And in this case, my lord,
You are the defendant.
I am the plaintiff. I have filed a suit.
Petitioner is the plaintiff.
Petitioner is the plaintiff.
Suit for?
It is suit for relation of amount of petty.
Suit for realization
Relation
of?
of produce of petty from the defendant. Still plaintiff and defendant are brothers, both are brothers. And between the brothers, it is case. It is so. Prayers are for declaring that the plaintiff and defendant being joint owner of Schedule A, Schedule 1, 2, and 3 of plaintiff. The plaintiff is legally entitled to give 50% share of respect of petty received and collected by the defendant number 2 and 3. Then second is that from the present agriculture year, the plaintiff shall be entitled to collect his 50% share out of petty directly from defendant number 2 and 3. And defendant 2 and 3 are the plowmen. They are the plowing.
RD?
They are the plowing. They are plaintiff. They are main person who are plowing. We are the owner.
Plaintiff
are-
and the defendant number 1
Yes.
are brothers and owner of the plot of land, which is being plowed by the
Defendant
defendant
two and
numbers
three.
2 and 3.
2 and 3. So second prayer is my lord. Second prayer is that for declaring that present agriculture year, the plaintiff will be entitled to collect his 50% share out of petty directly from defendant number 2 and 3. And or from the defendant number 2 and 3 are liable to give 50% of the petty directly to him.
Yes, then what had happened?
So now the defendant number 1 appeared,
Who had appeared?
defendant number 1 and 1, 2 and 3 all are appeared, all
Oh.
have appeared in the case, my lord. And defendant number 1 says that in the WF, my lord, WF is at page number 33.
Hmm.
The defendant number 1 says that they are owners in respect of 2 plots of land,
Hmm.
but regarding third number plot of land, third plot of land, another brother's share is also there. And he also admits that, yes, the defendant number 2 and 3 had been given for cultivating the land. They are cultivating the land, and according to it, we have to receive our share from them. And he has not denied the share of the plaintiff.
Hmm.
He has not denied the share of the plaintiff. He is said, yes, plaintiff is also entitled to his share.
Hmm.
Thereafter, the defendant number 2 and 3 both has appeared in the case, and they have also admitted that yes, the land belongs to defendant number 1 and 2. They have engaged me for cultivating, and previously they used to give entire produce on behalf of the defendant 1 and 2 to the defendant 1. Because defendant plaintiff number 1 resides at Guwahati, he is a practicing advocate at Guwahati, so they used to give his share also to his elder brother. That is admitted fact. Now, after filing of suit, after filing WS, the defendant number 2 and 3 had written a letter to the plaintiff to collect his produce because you have filed a case against us. So we have now handed over the share of the defendant 1 to him, and your share is lying with us, you make collect. Accordingly, we have collected. So thereafter, we have filed an application under order 12, rule 6 for passing a decree on admission. So our prayer, my lord, our
Where
prayer,
is the admission?
my lord,
Where is the admission?
my lord, the admission is clear, my lord. The plain,
Where?
My-
Admission in the form of the letter.
firstly, my claim has not been denied by defendant number 1 also, and defendant number 2 and 3 also in their WS admitted. 2 and 3 also.
One has said for so far as the third plot is concerned,
Third
there's
plot. Regarding third plot only, because third plot maybe that will be kept aside, but regarding plot two plots, there can be decree only regarding 2 plots,
let us see the impugned order.
my lord. My lord, that is at page number 116, my lord.
116.
1 month, my lord.
Yes, please.
Let us see the findings, my lord. I am coming to the findings, my lord. Page 121 is the finding, my lord. Page 21, my lord. There are 13,
Just a minute, please.
my lord. Page 121.
Just a minute, just a minute.
My lord.
Page,
Page 121.
internal page,
Inter, page number 1, internal page, it will be page number 6.
6, yes.
Yes,
Paragraph 12,
there are 13, my lord.
13, yes.
Under the present facts and circumstances, it appears that defendant 1 did not categorically admitted the claim of plaintiff made in the incident, and there was no clear admission of defendant 1. Rather, defendant 1 has filed written objection in the instant case also, and raised the issue of non-joinder of necessary parties which could not be brushed aside. That scheduled lands are not partitioned yet, and the defendant number 1 clearly stated that at the event of partition, he would not have any objection, but the instant suit is not for partition suit, and to decide the issue already framed in the suit. This court is opinion that merit of the case must be gone into and parties to be given opportunity to prove their stand by adducing evidence, and mere admission of defendant 2 and 3 would not be sufficient to pass judgment on admission, and there are material facts that needs to be adjudicated upon, and without such deliberation, passing of admission degree at this stage would not be appropriate at parties and others, if any interested in suit, would be prejudiced. So, but my lord, the learned trial court have to
Yes.
consider the WS filed by the defendant number 1. In WS filed by the defendant 1, my lord, we find that he had raised some objection regarding issue regarding one plot of land, but regarding rest of the plot of land, he said that yes, we are equally owner of this plot of land.
Yes.
WS, my lord, WS may be assigned, my lord, at page number 94, my lord. Sorry, it is written objection, my lord. 894 with written objection, my lord. WS is,
Your application
my lord,
for passing of a judgment
my lord,
on the basis of alleged admission
Right.
was for the entire suit.
my lord. That is that.
A judgment cannot be passed partially.
My lord, it is for partial judgment.
Partial
Court may-
judgment.
Court may call the relief, my lord.
Under what provision of law? Partial
No, 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 no.
judgment.
Partial judgment, that is order 12 rule 6, my lord, on admission. Court
Order
may-
12, Rule 6 will be a judgment on admission.
Admission,
Can it be a part of the cause of action?
my lord.
Can it be for a part of the cause of action?
Yes, my lord. That happens, my lord. That was, my lord, actually, my lord. For a part, court may decree a suit in part, my lord. That is what, that was,
And the other part,
other part, to trial will go. Trial will proceed, my lord. That is the, my lord.
we don't find that there is any gross illegality. Unless there is an admission clearly.
My regarding, my lord, schedule number 1 and 2, there is clear admission. That, yes, this property.
Have you made your third brother a party in the plaint, in the
That
suit?
is not my, actually, my lord, the plain, brother, somehow his name is appearing, but his name will be deleted. But he
No, that
never
is-
come to claim his land, that land.
That is your version.
That is that.
That is your
That
version.
is correct, that is correct.
But not arraying his a party. After arraying him a party, he does not contest, that's a different matter. You know
Right.
but
Right.
not arraying and thereafter praying for a judgment on admission without making him a party.
But my lord, regarding schedule 1 and 3 plot of land, there is clear admission of the defendant woman.
The defendant
So-
number one is one of the parties interested whom you have arrayed. There is another defendant,
My lord,
another party whom
another
you
brother,
have.
my lord, only his name is appearing in schedule 2 plot of land. Regarding schedule 1 and 3 plot of land, he is not at all connected with it.
How do you say?
So he,
What is the basis of your statement?
neither, my lord, his name is mutated in the revenue court.
No, what is the
No.
basis of your statement? Let us see. At the revisional court, aren't we required? Prima facie, it seems there are three brothers. And one brother has said that 1 and 2, I may not have any objection. And that is also not a clear admission.
Regarding my lord, WS Melu can be seen, my lord, page number 33, my lord. WS my kindly see, sir. That it is not true the schedule 1, 2, and 3 lands are in the name of plaintiff and the defendant 1. Land of schedule 1 and 2 are in the name of plaintiff and defendant 1. Land measuring 9 bigas, such as patta number 452 of schedule 3 land are not only in the name of plaintiff
Heard.
and defendant, but it's also.
S. Sharma, learned counsel for the petitioner who has filed this application under Article 227 of the Constitution of India, challenging and order dated 28/5 so and so, of course, by the aforesaid order, comma, the Ms. J case number 11 of 2024 has been rejected. And the prayer, Ms. J case number 114, which was filed under order 12, Rule 6 has been rejected.
My lord, only one thing in terms of time.
Hmm?
Only one thing.
Now we are issuing notice, we are not dismissing. We would have discussed. That notice be issued returnable on 24th of July, 2024. That steps be taken for service of notice upon the respondents by registered post with AD. Steps within 2 days.
Wait, please.
Item 3,
Item 3.
you are not there.
Pilot, I'll file the wakalat number. ma'am.
Okay. Biswajit Das,
This is it. Pilot, here,
Where-
pilot,
where is your wakalat number?
pilot, I will file in the meantime.
You will file.
I'll- If my lord allows, my lord, otherwise, my lord,
We'll allow, but you should have at least one counsel who is on record with you. There are different set of counsel, at least one counsel should be there. We don't mind hearing any counsel if he's authorized, or you can represent any other counsel, but for the sake of, okay, what is the matter?
my lord, I filed a suit for divorce, my lord, under section 13(1) into marriage act. That
Hmm.
suit was decreed.
Just a minute, please. Petitioner is the first party.
First party. Husband.
Suit for decree of divorce
Decree of divorce, my lord.
in a district court.
District family court, Kamrup, my lord.
Oh,
Family court.
here,
That suit proceeded ex parte.
divorce. Family code, Kamrup.
Come,
Suit proceeded ex parte.
ex parte.
Then
And it was decreed by judgment and decree dated, my lord, 17/7/2023.
17/7/23.
2023.
So decreed.
Decree. my lord. Hereafter, my lord,
Decreed ex parte.
ex parte.
Okay.
Hereafter, on 16/8/2023, my lord, the
16/8.
wife filed an application under order 9 rule 13 for setting aside the ex parte decree, my lord.
Okay.
That was allowed, my lord, by order dated 15/5/2024.
15/5/24
24,
allowed.
allowed.
Okay.
Now, the wife in her application under order 9 rule 13, my lord, she had given 3-4 grounds. One of the ground is that after receipt of the notice, summons from the court, my lord, she thought that it was a communication from the office of her husband, and so she signed it. And thereafter, because she was unable, at page 33, my lord,
Okay.
at page, my lord, comes page 34, my lord.
30?
34. In paragraph number 2, she has given a reasoning that the father of my husband stayed in certain church. Third liner, since 5 years still, I am ousting from the aforesaid house, 25th December 2020.
Page 34, paragraph
Paragraph 2,
2. Which line?
that third line,
Third line where?
since 5 years,
There's no 5. Page 34.
34 months.
Paragraph 2 is continuation of paragraph 2.
My lord. Then page 33, my lord,
Internal page 2 perhaps.
internet page 2,
That is 33.
30. It's wrongly.
Third line.
Third line. I'll
When?
start from the beginning. That the father of my husband stayed in railway quarter number so and so since 5 years still, and are ousting from the aforesaid house 25th December 2022. When I was staying with my husband at railway quarters, certain Jalukbari district, Kamrup, Assam, filed the FC civil case number 1483/2022 and served the notice on me, where I put the signature, as I believe that the letter came from the office of the respondent petitioner, my husband, and given the letter to my son directly, and my son read it and asked to his father what type of false case instituted against my mother. Then the respondent petitioner promised that he will not continue the case and withdraw the same. And by this way, my husband, petitioner, and also my father-in-law obstructed me from appearing before the honorable court. My lord, if I would have stayed the case or I have withdrawn the case, my lord, then the second reasoning that he has given, that we obstructed her from contesting the case, that is again contradictory, my lord. Once he has said that she took the letter thinking it to be the official letter of her husband, she ought to have given it to the husband, my lord. Instead, she gave it to her son. And secondly, she says that the husband was willing to withdraw the case. And if I was willing to withdraw the
That
case,
may not be contradictory because these are sequence of facts. He took the letter as if it was a letter from his office, then found and signed the summons, then found that it was a summon from the court, matter was discussed. He said that I will withdraw the court. These are not improbable things.
and thereafter, my lord, she has said that I have obstructed her. I along with my father-in-law. If I had withdrawn the case, then there is no question of obstructing her from appearing in the court, my lord.
The meaning which you are trying to assign
My lord.
regarding obstruction,
Right.
the use of expression may not be correct. She has also not only named the husband, also father-in-law, that none of appearing or contesting because he'll not continue. That is her understanding. Whether it's right or wrong, that's a different matter.
Subsequently, my lord, he was ousted from the house. That is her version on 25/12. My lord.
Mm.
Hereafter also she has not contested. So where is the sufficient cause, my lord?
When was the ousting?
That she has written, my lord.
Mm.
Paragraph number 3, that after filing of the application number served a notice upon it took the signature, thereafter tortured violently upon me physically and mentally and ousted from my matrimonial house on 25/12/2020. So judgment was passed on, my lord, 11/7/2023. Hereafter also she could have very well approached before the learned court below, my lord. Instead, she filed a maintenance case. So she had knowledge, my lord, that the case was going on. So that is my contention that, my lord, she had failed to show sufficient cause so as to attract, my lord, Order 9, Rule 13 of the CPC.
When was the maintenance case filed?
My lord, most probably in the month of January 2023.
When was the application under Order 9 Rule 13 filed?
16/8/2023.
No, that was it was filed on 16/8, allowed on 15/5.
15/24. And in fact, my lord, she has not at all stated in her application when she came to know about
No
the-
application was filed against the order to proceed ex parte. It was only under the ex parte order.
yes.
Oh. Heard Sri A. Iqbal, learned counsel, who has appeared on instruction for the petitioner. The instant application has been filed under Article 227 of the Constitution of India against an order dated 15/5/2024 passed by the learned Family Court number 2, Kamrup Metro, in Mijje case number 108 of 2023, arising in FC Civil, bracket Civil, case number 1483 of 2022. Full stop. The petitioner is the first party husband in the FC Civil number 1483 of 2022, which was instituted for divorce. Full stop. It is submitted that since the respondent opposite party did not appear in spite of receipt of summons, comma, there was an order dated 17/7/2023 to proceed ex parte. No, the suit had proceeded ex parte, which was finally decreed by the order dated 17/7/2023. Full stop. The application under Order 9 Rule 13 CPC was filed by the respondent opposite party on 16/8/2023 and vide the impugned order. The same has been allowed. Full stop. Para, the learned counsel has drawn the attention of this court to the averments made in the application under Order 9 Rule 13 and has contended that irrespective of the projection made that the summons were received and signed under a misconception of fact, comma, there are sufficient materials, including the aspect of filing a maintenance case by the respondent opposite party, which would show that she was in the know of the tendency of the divorce proceeding. And even thereafter had not come up for contesting the same. Full stop para. Let notice be issued. Returnable on 24th of July 2024. Let steps be taken for service of notice upon the respondent by registered post with AD in both the addresses mentioned in the cost title. What is the next date?
Next date is 26, tomorrow.
Tomorrow. Okay. Para. The Learned Council prays for an interim order. Para. Considering the facts and circumstances and in the interest of justice, comma, it is directed that till the next date fixed, further proceedings in what is the case, original
FT
case,
civil case number
in
one,
FC civil so and so, original to 14383,
1 4.
before the family judge
Number two.
shall remain suspended. Full stop. The interim direction would, however, be reconsidered on appearance of the contesting respondent.
Keep noted.
Mr. Roy, what is this?
This petition is arising out of a probate proceeding lot. And the present petitioners were not implemented in the probate proceeding. Then by filing an application under Order 1 rules, the present petitioners were implemented. Then Lord.
You were originally not made a party.
No,
Not made.
so the
Alright.
petitioners are the legal heirs of the deceased who executed the will. Lot.
How many petitioners are there?
There are lots of three numbers.
Three
Wait, what?
petitioners. Completed. You claim that you are legal heir of the
And the executor of the.
okay.
Because the executor of the will lordship was unmarried.
Now, what is your cause of action here?
Here, cause of action is this lordship, in the probate proceeding, the probate was filed before the Honorable District Judge Kamrup Lord. And subsequently, it was transferred to the Court of the Additional District Judge number 2, fixing a date for the appearance of both the parties. The defendant, the respondent lordship did not appear on 4-5 dates consecutively.
Respondents means, oh, here, the first party.
Yeah. Then in the learned additional decision number 2 was pleased to dismiss the probate case lordship for default on 20th of July 2013.
2013.
1
Case was dismissed, this case dismissed for default.
default. On 2 grounds that there was no appearance as well as no steps were taken. Lordship as ordered by the court.
Okay, then
Then Lordship, the respondent filed an application under Order 9, Rule 4 of the CPC for the restoration of the proceeding. And the present petitioner also filed objection. Thereafter, by the impugned order, the learned additional decision number 2 allowed the restoration.
on this order 9 rule 4 has been allowed.
Allowed.
Which order?
Order is Lordship page 20.
Page 29.
20.
29.
page 20, annexure 5.
Yes, please.
Para 2 Lordship, petitioner case in brief is that being appointed executor, he filed a petition registered with case number 7 grant of probate of the will executed on 21st/12/2009. Initially, the case was pending in the court of the district judge Kamrup, Guwahati. However, the Bhide order dated 4/4/13, the case was transferred to this court, fixing the date as 4/5/23. This 4/5/23/13 was the date lordship for appearance of both the parties. But due to the inadvertence of the conducting advocate, there was a mistake in taking date for appearance after transfer, and in the result, on 20th/7/13, finding the petitioner absent on last 3 dates, the case was dismissed for default. It is pleaded that after transfer, no notice was served on the petitioner as well as due to non-appearance of the advocate on the date fixed. There was no negligence on the part of the petitioner. Hence, the petition for restoration of the said missed case number. On the above petition, the impleaded opposite parties in the probate proceeding have submitted their written objection with pleadings that the grounds made in the petition for restoration are false. It is also pleaded that material fact has been suppressed in title execution number 4/2009, pending before the court of the Munsif number 3. Kamrup, the present petitioner has filed several petitions intimating the court regarding the pendency of this case before this court with the date fixed. So the question of wrong taking of date due to inadvertent is nothing but false statement. Under above fact, petitioner has prayed for dismissal of the petition for restoration of the misprobate case number 10. Para 4, during hearing, the learned advocate for the petitioner has reiterated the plea taken in his petition for restoration. It is also submitted that though lastly got the knowledge of the case pending on 20th/7/13, but due to inadvertent mistake, cannot take steps and deposit the will as directed on the date of transfer. On the other hand, learned advocate for the opposite parties has submitted certified copy of the petition filed by the petitioner and the copy of the order sheet as passed in title execution number so and so by the learned court of the Munsif number 3, Kamrup, Guwahati, and vehemently argued that the petitioner even did not comply with the order of the court by furnishing copy of the will and taking wrong date cannot be believable, as the case was transferred by fixing another date for appearance before this court. Hence, on false ground, the case cannot be revived. I have considered the submission of both the sides and gone through the record. On receipt of the petition, missed probate case was registered and petitioner was directed to take a step in for notice on the OP number 1. In the meantime, 3 persons got them impleaded in the proceeding, and on that order was the case was transferred to this court. It is fact that while passing the order for transfer, Honorable District Judge Guwahati has fixed the date for appearance on 4/5/13, and hence the ground that after transfer of the record no notice was issued to the informant is not sustainable. From the record of probate proceeding which was tagged with this case file, it appears that after receipt of the record on 4/5/13, the petitioner was absent on 4/5/13, 6/6/13, 29/6/13, and lastly on 20th/7/13. Finding the petitioner absent without a step, the case was dismissed from the certified copy of the petition filed before the learned Munsif number 3, Kamrup, Guwahati, in title execution number 2 and so. It is apparent that the petitioner has the sufficient knowledge of transfer of this case to this court, and that probate case was fixed on 20th/7/13, even though no step was taken on that date. However, considering the fact that the plea taken is of inverted mistake in taking a step for 27/13, the date on which the case was dismissed, it is a fact. It is a fact to be presumed on the basis of the affidavit annexed to the petition. This is a case for grant of probate of a will. Taking the probate on a will is mandatory part of the law under Indian Succession Act. And no restoration of the petition for probate cause irreparable loss to the beneficiary of the will. Upon whole notice has not been upon whom notice has not been served in spite of the taking steps by the petitioner for the fault of the conducting lawyer, beneficiary under the will cannot be allowed to suffer. The inconvenience caused to the implicated opposite parties for the dismissal and subsequent restoration may be compensated in terms of money. The grounds shown for inverted mistake in taking the steps on 27/13 appears to me as a sufficient for restoration of the proceeding right of probate case number so and so. Considering the above petition for restoration of probate number so is allowed under Order 9 Rule 4 of the CPC, subject to payment of cost of ₹1,000 payable by the petitioner to the implicated opposite parties for the inconvenience caused to them. Both the parties are directed to take a step in the probate case number so and so further instruction. It is also come to my notice that along with the petition for grant of probate, the will or its copy was not annexed. The petitioner is directed to deposit the original will along with sufficient number of copies for the opposite party case record and also deposit the amount of ₹1,000. Deposit the amount of cost of ₹1,000 onward payment to the implicated opposite parties on 8/7/14. It is made clear that for restoration of case number 7, the deposit of amount of cost of rupees and the will is a condition precedent. This amount was also not deposited, Lord. So far, I have received the instruction from you. So my humble submission is this: I would have not object the restoration, but Lordship, having the full knowledge and information regarding the proceeding probate, the Lordship may come to the record of this title execution. Lordship will show that the respondent, Lordship, who filed the probate petition has full knowledge of the date and the happening in the probate proceeding.
Title execution means which title execution?
Lordship, the person who executed the will, he filed a suit against his own, that is the present petitioner, predecessor interest of the present petitioner. Suit was decreed in favor of the executor of the will, and thereafter he filed a title execution. So in title execution against the predecessor interest of the present petitioner. So that title execution proceeding was going on, in which Lordship, the same advocate who was appearing for the executor of the will was appear on behalf of the deceased. Lord, your Lordship may please to come to page 33.
3-3.
The order sheet will show that he has full knowledge and information, and the learned trial court also come to conclusion that he has full knowledge and information regarding the date slot. But in spite of that, the petition was allowed. This is the order dated 13/3/13, Lordship passed in the title execution number 49, that the DA expired, but has left a will which is being probated. Probate means case number 113 has been filed in the court of the district Judge Kamrup fixed on 15/3/30. The certified copy of that order passed in case number such place for some time to produce the order of the court. So this was filed by the advocate of the executor of the will, Lord. So regarding, he stated here, Lordship, regarding the pendency of the probate proceeding. Then, Lordship, the next page 35, Lordship.
35.
Yes, Lordship, annexed 7. This petition was also filed filed by the learned advocate of the executor of the will that the decree holder has expired and he has a last will. The will has been filed for probate in the court of the district of Kamrup and number is people miscellaneous probate case number. That the case has been transferred to the court of the additional district number 2 and next date has not been fixed. Absolutely false averment. Because while transferring the case, the learned district judge has directed both the parties to appear before the transferee court on 452. So this false statement was made. Then Lordship,
Where is that order of transfer?
yes, order of transfer. Lordship, it is mentioned in the improvement order itself, page annexure 5 Lordship.
Lecture 5.
Annexure 5.
Okay, doesn't matter. Then, no, you are contending that they had knowledge about.
Yes, there are
Proceedings.
other order sheet of the title. I think. Lordship, it is clearly mentioned in annexure 5 Lordship, first page. Void order dated line Lordship 1, 2, 3, 4, 5. Line 5. However, void order dated 4/4/23, the case was transferred to this court by fixing the date on 4/5/13 law. Then Lordship, may be pleased to peruse the other order sheet of the title execution, which further discloses
So
that,
there are materials to show that they were having knowledge.
no,
But in the second petition at 35, they did not mention the date. That it while transferring, the date was also fixed.
Yes.
They had stated that no date was fixed.
so if a false averment is made on affidavit law, the petition under order 9 rule 4 should not wait. Because no sufficient cause has been. And no advocate diary was exhibited, Lordship. Not diary was, page was filed, showing the wrong posting of the case. Order 9 rule 4 Lordship provide the sufficient cause should be shown. For it. And if the restoration is not allowed, Lordship, the respondent will not suffer anything because under order 9 rule 4, he may bring a fresh.
Subject to the limitation.
Yes, go with a condemnation petition. I would have not preferred this revision petition, Lordship, but the facts are so, it is,
That is why cost has been imposed.
that has been not paid, not, that was a condition precedent. That post was a condition precedent,
You have the LCR in this court, how will the cost be paid?
Lordship.
You have the LCR call for by this court, where will the cost be paid? LCR has been called in this proceeding.
Hmm.
There is no case record in the lower court. Which date the cost to be paid? Under what proceeding?
Can be paid, Lordship, within Adi. Generally, cost in the judges.
So when the LCR is in this court, there is an order while issuing notice. The LCR 25/9/2014, we have just checked. The LCR has also been called for. But that's a different matter that cost can be enhanced also. That's a different matter.
No, by showing the certified copy, usually we deposit the Nazir.
Where?
The Nazir.
No,
Actually-
where and in which case? Which case records?
No, simply Nazir, right? Case number, this and that. and
Records
on
are where-
production of
where-
certified copy.
Where will it be recorded? The records have been sent to this court.
No, that is correct, Lordship.
If the records are not there, where will they deposit the cost? We are not um, even for a moment saying that they have not taken the correct approach. The cost part can be taken care of, even it can be enhanced. But yes, you have made out a case that the negligence appears to be there on 3 dates and not noting the date while the matter was transferred by the district judge to the additional district judge. Date was also fixed.
Thereafter, 5 dates were given.
3 dates.
Three dates, sorry. But did not appear. And see the affidavit, Lordship.
Yes, Mr. Sharma will be appearing. Yes. The court is not required to wait for indefinite period, 3 days. How long? Okay, here the learned judge has given reasons that case should be decided on merits, but there is also a provision for dismissal for default. It's recognized by law. And this dismissal was not done on the first date. You are given chance, opportunity, and you had not taken steps also. Under those circumstances, do you think that this order which has been passed is in accordance with law? Or alternatively, the prayer of Mr. Roy, is it an unreasonable prayer? Switch on the microphone. Your microphone is not working perhaps. Yes, now it's working.
My senior submissions are reasonable in life.
No, go ahead, Janeto. Give me a second. No, it's working. We'll amplify it slightly. Oh, come on, Brahidi. Just try.
My lord.
Yes.
So my seniors, prayer, your lordship, are absolutely justified.
Now, what?
Right?
Yes. What is your submission?
I
We have heard the Mr. Roy.
Yes.
What is your
I-
submission?
In fact, your lordship, the title execution orders also indicate that we are aware of the dates. But that is an excuse that I cannot take. That's the reason I cannot rely on. The only aspect that I can rely on, your lordship, is at page 31, the findings of the lower court, the Senate lower court, your lordship, at paragraph number 7. That since the matter pertains to the aspect of will, bequeathing of property of a dead person,
31,
at page 31, the last paragraph, your lordship.
paragraph 7.
Yes, that will be the only recourse that I'll take to report for this one. The matter pertains to the issue of will of a dead person bequeathed to beneficiary. The matter ought to take its turn. I lordship then have an observation on the aspect of the cost, course, but also should be seen, your lordship, the response number 2 has not appeared despite it has been served. Response number 2, yeah. They have also not appeared. Maybe subject to what your lordship finds determined. They also should be heard since they are an interested party in the matter. But
No, if
again,
they have not appeared
they're
on their
not-
own
yes,
volition, we
yes,
cannot
yes,
force them to
absolutely,
appear.
absolutely. Sir, that is my only ground I'll take. But
No,
rely-
was notice served?
Notice to have.
Hmm?
Notices were served, they have not appeared.
Directed so and so, they could first steps. Notice issued or should with regard to service and list of an employee. F1 part 2. Part 2 file sonata. Part 2 F flag FY1. Mm. 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 Yeah. Mm. Officer, Nakul Diab, Police Rafi. including even the for even dictionary to translation হয় জানো 812 ইয়াতে সিল কৰা কথা আছে নেকি মইতো পোৱা নাই সহি ৰাখি পৰুৱানাত সহি কৰে পঢ়ি উঠি পঢ়ি চাই ৰাখি পৰুৱানাত সহি কৰে সিলৰ কথা আছে নেকি এটা দি লিখছে সাইন এন্ড সিল লাষ্টৰ খিনি আছে সিলৰ কথা ক'ত কৈছে ইয়াতে অসমীয়াখনত সিলটো কৰা নাই চহীটোতো ওপৰত এইটো বৈশ্য সেইটোৱে চহী কি বৈশ্য দেৱেন বৈশ্য আৰু এখন লিখিছে লহকৰে লিখিছে দেৱেন লহকৰটো জাৰি কৰক সেইটো হ'ল হেৰি তাৰতো সিলটো নাই সিল নাইতো সিল কৰিব পালে ইয়াতে দিগদাৰ ঠিক হ'ব somebody in the office, some employee has received the usual process notice. The registered AD, there is no conclusive proof of service because there is no return. But the usual process has been served. Yes, what are your submissions on the interpretation? How is
Yes. My submission-
an application under the aforesaid provision is to be
Yes.
considered?
Your Lordship, Order 9 Rule 4, Your Lordship, attributes the aspect of default on the conducting council. Here, Your Lordship, in a matter of probate, my only submission here would be. that
No,
the
no,
penalty-
why have you made your first submission that it is regarding the default of the council? Where is it written?
No, in fact, the place states, Your Lordship, the council was responsible for once.
No, this case is a different matter. Facts of this case be different.
Yes.
We're on the provisions of law. There is not,
Yes.
it's not council centric. It's a normal proposition of,
Yes.
it's a law laid down.
Here, in fact, if Your Lordship sees that the aspect of default has been pointed out at page 31, where it says that for the fault of the conducting lawyer, the beneficiary under the will cannot be allowed to suffer. I'm not the beneficiary here. In fact, if my actions here would flow and accrue rights to me, then Your Lordship, I would say that there was some default.
Who are you?
I'm the executive report. Respond number 1. The beneficiary is respond number 2. There are some different terms. That is the ground for taking. That was the rationale was provided the learned court below. The story of the all that it need also it has been discovered by the learned court below. Should not go on another beneficiary of who. So I'll take that submission itself that order 9(4) primarily leads to default falling on the parties in here the beneficiary is separate third party. That was the reason it was taken for the file with court, and that was the reason why.
But who had instituted the probate case? Who had instituted the probate
The
case?
basis of a will, yes, sir.
Who had instituted?
Mr. Bhuvan Chandra Das.
He,
I had,
no, he is one of the beneficiaries.
no, the beneficiary is phone number 2.
Okay. Let us see the application. The application, original application, is it a part of this revision?
Okay.
We'll have this.
Original plain probate petition has not been, it will be
No.
available in the trial court.
LCR, we're just having a look.
I am having a copy if you're.
No, we'll have it, don't worry. Okay. The person who had made the will, he was he did not have a family. And the present Mr. Roy's clients are, how are they connected?
Lordship, the executor of the will and the father of the present petitioner, they were on brother. So executor of the will lordship did not marry. So he died unmarried. So as a class 2 legal heir, the brother to the
You want to challenge the will
will.
in the probate case?
Yes. Because this was the ancestral property law.
Okay.
And lordship, but the learned trial court had to have considered the go as per the provisions of Order 9 Rule 4 whether sufficient cause has been shown. In the upper para of the impugned order, the learned trial court has held that
No sufficient cause.
yes, not sufficient cause. But what if a petition is allowed or dismissed, what will be the difficulties or will be faced by the party? That cannot be the lookout of the court.
Mr. Sharma, we are expecting something more on the provisions of Order 9 Rule 4. Read for the first time. This whole case is revolving under Order 9 Rule 4. You're reading for the first time.
And surprising thing is this lordship will was not filed along with the probate petition. Even then the court issued the notice to the party. Till that it has not been.
Please read it, and you have not brought any case laws, but what do you say on this? What is this provision about?
Yes, Your Honor. When suit is dismissed under Rule 2 or Rule 3, the plaintiff may, subject to the law of limitation, bring a fresh suit, or he may apply for an order to set the dismissal aside. And if he satisfies the court that there was sufficient cause for failure as referred to in Rule 2, or for his non-appearance, as the case may be, this court shall make an order setting aside the dismissal and shall appoint stay for proceeding. Lordship, as per Order 9, Rule 4, which has also been noticed by the learned court below, that there was default on my, there was a default on. Here, your Lordship, I would like to make a small differentiation subject to what your Lordship says. That here the rights, if you think the petition goes in my favor, the rights is not accrued to me, but rather to a third party as a beneficiary.
That are on the facts of the case.
Yes. Yes.
What do you say on the provisions of this law? Mr. Sharma, this kind of thing will not help you. You have not done anything. Simply standing here and showing your face will not do, Mr. Sharma.
Yes. Your Lordship permits me one day to scale up on the matter, Your Lordship. That is what I'm admitting. Just,
We don't give this much liberty to young councils.
all guys,
Young council needs to be prepared.
Yes.
This is a matter of 2014.
Yes. 10 years.
This is a senior council having some difficulties. It's a different matter. Yes, right. The present application has been filed under section 115 of the Code of Civil Procedure, challenging an order dated 16/6/2014 passed by the learned Additional District Judge number 2, Kamrup M, in Miss J case number 76 of 2014, arising out of Miss within bracket probate case number 1 of 2013. Full stop. Please have your seat. By the impugned order, comma, the aforesaid Miss case was allowed and the case was restored to file. Full stop. Para. I have heard three. S.P. Roy, learned counsel, for the petitioners. Full stop. I have also heard three. M. Sharma, learned counsel for the respondent number 1. Full stop. The respondent number 2 has chosen not to appear in this case. Full stop. Para. 3. Roy, the learned counsel, has submitted that in the probate case, comma, the present petitioners were not originally made parties, and accordingly, they had filed impleadment application, whereafter they were impleaded as parties. Full stop. The petitioners claim that they are legal heirs of Bhuvan Chandra Das, who had executed the will in question and was the subject matter of the probate case. Full stop. The learned court, wide order dated 27/2013, had, however, dismissed the case on default on both the counts of non-appearance of the parties and not taking steps. Full stop. Subsequently, comma, the opposite party number, the respondent number 1, had filed an application under Order 9, Rule 4 of the Code of Civil Procedure for restoration of the probate case, in which the present petitioners had filed objection. Full stop. Wide the impugned order dated 16/6/2014, comma, the petition for restoration was allowed, however, with a cost of rupees 1,000. Full stop. Para. Sri Roy, the learned counsel, has submitted that prior to passing of the impugned order, comma, there were at least 3 dates in which there was continuous default on the part of the present respondent number 1 in appearing before the learned court. Full stop. It is also submitted that a title execution case was continuing and the action of the present respondent number 1 in filing application in that proceeding would prima facie show that they had full knowledge of the present case, in spite of which there was no appearance. Full stop. Para. By referring to the impugned order dated 16/6/2014, comma, the learned counsel for the petitioners has submitted that while the matter was transferred from the court of the learned district judge to the court of the additional district judge, comma, the date was already fixed, and therefore it could not have been taken, it could not have been contended by the respondent that the date was not known. Full stop.
Not fixed.
Not fixed, not known by them. It was fixed, yes, not known. Full stop. It is also submitted that the learned court, while considering the matter, had come to a conclusion regarding the negligence and default of the party in pursuing the case, and yet had restored the same to file by taking into consideration the effect, which full stop. It is contended that the consequence should not be the lookout of the court if the court is otherwise satisfied on the aspect that there was negligence and laches in pursuing the matter. Full stop. The learned counsel, Sri Roy, the learned counsel, accordingly submits that the impugned order dated 16/6/2014 is liable to be set aside. Full stop. Para. Sri Sharma, the learned counsel for the respondent number 1, has submitted that the fact of non-appearance on earlier 3 dates cannot be denied by him, as those are matters of records. Full stop. He, however, submits that the probate case was instituted by the executor and the beneficiary was the present respondent number 2. Full stop. It is submitted that the said Bhupan Chandra Das had died as a bachelor and had made the will in which the respondent number 2 has been made the beneficiary, and it is for their benefits, for its benefit, association, that the probate case was instituted, full stop. It is submitted that the learned court, while considering the case, had taken the cause of justice and accordingly had restored the case vide the order dated 16/6/2014 and had also 16, which does not require any interference, full stop. The Learned Counsel has also highlighted the aspect that cost was imposed upon his client for the default, full stop, para. The rival submissions have been duly considered, full stop. The materials before this court, etc. Materials before this court, including the lower court records, have been perused, full stop, para. This court has noticed that while has noted that while issuing notice in this case wide order dated 25/9/2014, the LCR was called for, full stop. Therefore, it is apparent that there is no further proceeding which has developed, and it is apparent that there is no further development in the case before the learned court below, full stop, para. The impugned order dated 16/6/2014 has noted that the default was because of the negligence of the conducting counsel, full stop. Though a wrong noting of the date was pleaded, comma, the learned court has also recorded that while transferring the matter wide order dated 4/4/2013 and fixing it before the court of the additional district judge, comma, the next date was also fixed as 4/5/2013, and therefore it is difficult to accept the submission that the respondent number 1 was not aware of the dates, full stop. The default / negligence on the part of the conducting counsel is apparent, which is also one of the consideration and observation made by the learned court, full stop. The learned court, however, has also taken into account the subject matter of dispute, which was for probate of a will, and the beneficiary was the respondent number 2, and the present respondent number 1 was only the executor, full stop. The application filed under Order 9, Rule 4 of the CPC was not by the respondent number 2, the beneficiary, but by the respondent number 1, who is the executor, and therefore the bona fide of filing such application cannot be doubted. Full stop. Para. The provisions of Order 9, Rule 4, CPC is for providing the plaintiff to file an application for setting aside the order of dismissal by assigning sufficient cause. Full stop. The said provision also gives liberty to the plaintiff to institute a fresh suit subject to the law of limitation. Full stop. Para. For ready reference, the aforesaid provision of Order 9, Rule 4, CPC is extracted herein below. Full stop. In the considered opinion of this court, the aforesaid provision, as a matter of abundant caution, gives liberty to the plaintiff to file an application for setting aside an order of dismissal by assigning good reasons, whereas the substantial right to bring a fresh suit subject to the law of limitation is still left open. Full stop. The intention of the legislation is to give an adequate opportunity to a party approaching a court to have a matter adjudicated on merits is apparent. Full stop. Para. The facts, however, in the instant case would show that the initial order dated 27/2013 passed by the court by dismissal of the case was after citing reasons. Full stop. In the application filed for restoration, the default on the part of the council has been cited as one of the main grounds. Full stop. The law is settled on this in this field that parties should not suffer on account of the default of an advocate. Full stop. However, the said excuse, if taken, has to be considered by taking into consideration by the other materials on record and not on a routine manner. Full stop. In the instant case, the approach of the learned court to go to explore the aspect regarding who is the ultimate beneficiary, who would be the ultimate beneficiary if the probate case is allowed, does not appear to be unreasonable. Full stop. This court has also noticed that while allowing the restoration, a cost of ₹1,000 has also been imposed. Full stop. This court, Sri Roy, the learned counsel, has however submitted that the cost is yet to be paid. Full stop. Para. After hearing the parties and on consideration of the facts and circumstances, including the provisions of Order 9, Rule 4 of the CPC, this court is of the view that the powers to be exercised under Section 115 of the CPC, under which the present petition is to be filed, may not require interference with the impugned order dated 16/6/2014. Full stop. Accordingly, the petition is dismissed. Full stop. The LCR is required to be transmitted back immediately. And the parties are directed to appear before the learned court on 18th of July, 2024, full stop. On the said date, comma, the respondent number 1 is also required to pay the cost which was imposed by the impugned order dated 16/6/2014. Okay.
If the cost is not deposited, then online may be recorded.
And only on deposit of such cost, comma, the further proceedings may be taken up.
Obliged.
You deposit the cost, Mr. Sharma.
Item 5. Lordship, please. Item number 11, your lordship. This matter was acceptably heard by Lordship G. Boruaya. And that court also wanted some documents to be filed and we have already filed.
Item number 11.
11.
When was it heard?
On 27/5.
You could have made this submission on 3/6. It came before this court on 3/6. It came before this court on 3/6. You could-
It was a date fixed.
No,
but the
you
court
could have
did-
made, you could have made the submission. We could have recorded your submission. It came before this court.
On that, your lordship, the honorable court was not sitting, that's why I was taken. For fact.
No, we said, we passed orders. A prayer for adjournment was made on your behalf. You could have said that same thing. We could have, instead of passing this order again fixing 19/6.
Anyway, your lordship, I have informed it.
No, we don't mind taking this matter by that court. But that court, it's not a parthead matter. So breaking the roster, it may not be proper. We'll make an observation. Let it go, and then if
Left one, 24, it may be fixed.
no, we'll not fix a date. We do not know whether this court will be there or not. Mr. Ali, what do you say?
I am now, actually, after hearing both the side, that
Okay.
court was.
We can record it as a joint prayer, joint submission.
But
The learned counsel for the parties jointly submit that this matter was extensively heard by a coordinate bench within bracket Justice, Honorable Justice D. Barua on 27/5/2024. And for para 24, when the appellants were directed to bring on record certain documents which has already been done.
So we have already filed.
Full stop para. Let the matter, let the aforesaid aspect be considered, be examined, be verified by the registry, and the matter be placed before the appropriate bench.
Next week, your lordship.
Will not fix the date. That availability we do not know.
Item 5.
Yeah, Agoroti is too.
May I please, your lordship. Lordship, appeal has filed for modification, lordship.
Item number
5, lordship.
for modification.
Yes, lordship. For releasing the entire amount of appellant number 1, 5, and 6, lordship. Judgment passed by the Railway Claims Tribunal, lordship.
Yes.
Appellants get compensation rupees 8 lakh with interest 6%, lordship. But the amount has divided into many parts, lordship. That is mentioned in the page number 21.
We had decided many cases, I think.
Yes, lordship.
We had decided some cases of this nature.
Yes, lordship. Yes, Lordship. I have annexed, annexed 25.
Yes, who is for the other side?
Lordship, in the course is SDI, Lordship.
Item number, this is item number 5.
Yes.
Yes, CGC, any CGC? Mr. Sarma bro? You do one thing, you see the court records. These are matters we have adjudicated on a number of occasions. You have the court records? We'll have it after some time. Okay? After 15 minutes. You have a talk with your colleague and show the concerned pages, okay?
Yes.
Where you have annexed the earlier orders.
Item 6.
Yes.
Competition for the matter, Your Lordship, for the day. And for the response.
What is the matter, Mr. Decker?
It's a amendment application has been partly allowed and partly rejected. So far, amendment of pleading has been allowed. So far, inclusion of 2 scheduled property in the prayer number 1 has been rejected on the ground that is bad under Article 58 of the limitation. Only unsustainable ground.
Luis, we had considered this matter on the last occasion at some length,
Yes, yes, sir.
14.6.
Yes, sir.
Why we had given time to the other side? What was the reason?
Earlier, one madam is appeared.
That is okay, but why was the time given, granted? We were on some issue when we had accommodated some time.
Yes, yes.
What was the issue involved?
Order 6 Rule 17 was asked that council.
Okay,
appearing
okay,
for the-
amendment.
Yes, sir.
Yes, Mr. Sharma.
Simple issue, Lord.
I have just briefed this handed over, but I have not.
Okay, okay, Wes, when?
I'll leave you, Your Lordship.
Friday,
Right.
on the prayer of 3M Sharma, learned counsel for the
So for now, one and
respondent numbers 1 and 2.
One.
There are more respondents.
No,
Respondents, list on Friday.
interim to one.
Para, interim order passed earlier to continue till the next date of listing.
All right.
Item 7 and 8.
Made this lordship. My lord, this matter is before your lordship because, my lord, the similar matters the lordship has already passed the judgment. But I would like to hand over the copy of the judgment to your lordship.
What is this matter about?
My lord, it's a service matter, the teachers who they were engaged. My lord, someone 30 years back, 18 years, 17 years, 15 years. My lord, they have exploited their service for long years. And my lord,
Which organization?
my lord,
Brahmaputra Valley Fertilizer Company.
Okay, oh, yes, yes, yes.
your lordship has already
That was
decided.
declared to be sick, then some, you had
Yes.
taken over, yes.
And
Yeah,
the-
oh, yes, yes.
It extensively covers, my lord, the same teacher.
It is a similar type of case, but in that case, your lordship has given a judgment in favor of the petitioner there.
No, if it covers, then we'll,
No, there's only one problem. In that case, your lordship, it was held that there was sanctioned poor. Our specific case is that these are not sanctioned.
no, in that case, what was your plea?
That case, I was not there. Just like Mr. Surin Sharma late.
My lord, it's a totally sanctioned post. The annexures are there. The lordship was, my lord, totally convinced with that. And their plea was that it was not a sanctioned plea. My lord.
Even in that case, it was
Yes,
the
even-
same plea.
Similar, my lord.
That
In
case,
toto, my lord.
that was not taken.
It was taken, my lord, with responsibility. I am stating before your lordship. I'll take your lordship to those position also.
Mr. Ahmed, have you ever had a look at this judgment?
Yes,
Then if the facts are similar, then we'll not go for adjudication.
Exactly.
This not be proper.
Everything is in total. Only.
You
that
have
one-
the, see, you have all the liberty to test this judgment in, before a DB. That's a
No.
normal course of law. We have nothing to say. But once we have expressed our views, we cannot reopen the issue.
Only one thing I want to point out.
Please.
No.
Unless there is some substantial difference in the issue involved,
Yes.
for a little bit of the here and there, we are not going to change or reopen
Only-
rather. It's not question.
Only that point, whether it is sanctioned postponed.
But which part we have taken into consideration?
That your lordship has taken here.
Let me see,
Paragraph 20 of. your
para
lordship.
20, my lord,
20.
in your lordship judgment.
We'll have the same judgment.
Lordship.
Exactly, my lord, the fact and the
We'll
legal
have the
position
same
is
judgment.
same.
Heard Sri S. Dutta, Learned Senior Counsel, for the petitioners in these two cases, while the respondables 2 to 7 are represented by Sri Amjad Ahmed, Learned Senior Counsel, assisted by Sri A.M. Dutta. Full stop. The issue in this case pertains to the contractual teachers of the Brahmaputra Valley Fertilizers Corporation Limited, who have been rendering their services for about 17 years.
One is 30 years.
One is 50.
Bornelli is 30, the next case is 30 years.
For 17 years in WPC 6558/2023. No, about Bornali to Bornali Kagol. For 30 years in WPC 6015 of 2023 and 17 years
6 to 18 years.
in 6 to 18 years.
You can
6 to 18 years in by the petitioners in WPC 6558 of 2023. Full stop. The petitioners are claiming regularization of their service. Full stop. Para. This court has been informed by Sri Dutta, the Learned Senior Counsel, that on exactly similar circumstances, this court had passed a judgment dated 23/4/2024 in WPC 7253 of 2019, whereby the writ petition was allowed, directing the services of the petitioners in that case as teachers in the Brahmaputra Valley Fertilizer Corporation Higher Secondary School to be regularized. Full stop. This court has, however, noticed that in that case, certain conditions were available, which have been recorded in paragraph 22 of the judgment, including continuation of service for 30 years. Full stop. Be that as it may, comma. This court is of the considered opinion that the principles laid down in the aforesaid case of Pranjal Datta Supra, ऊपर में Pranjal Datta लिख देना, would be applicable in these two cases, and the cases of the petitioners are to be taken up for regularization as teachers in the aforesaid school by following the parameters laid down in the earlier judgment dated 23/4/2024. The writ petitions are accordingly disposed of. I think there is a difference. We still give you some liberty. You can apply your mind, but pass reasoned orders. But if the difference is not too much, you are required to regularize.
My lord, regularized from the date of their appointment,
Appointment is.
from the initial, my lord, that is what.
No, same, we are not saying anything else, same parameters. Okay.
My lord, if
IFR.
the WPC 6558,
Yes.
my lord, I clarify certain things. My lord, they all are not above 10. My lord, 18, 11 years, 13
Now
years.
he has said, Mr. Ahmed is a 6 to 18, we have said.
Follow.
What is the IA4? IA4?
No, this is all over. This is annexing the appointment of
I has been disposed of,
Purovila.
I disposed of further. Okay.
much of it.
Okay, hello, नाम हम 60 लिख देना है, Paramesh Datta versus so and so.
Only, we heard that the other matter has been appealed again, the earlier judgment.
We can record that, I think. Can you give the writ appeal number?
Number is not yet only the serial number is.
Filing of writ appeal is not going to, my lord.
No, we are not, that you need not explain. But the fact of filing, we can probably, it's okay.
Published.
Identify time being.
What is, here notice they have not challenged the validity of the quantum of the compensation. These only challenges the
Yes,
arrangement, how it is.
yes.
So in that regard, also, I don't think this government has, it depends on the objection in that regard. Second thing is that, I have also checked that her Wakaldama, this also filed the Wakaldama on behalf of 1, 5, and 6. So this is, I think, because I had to know, because if she files the Wakaldama unilaterally, without, that's an important part, I think, okay. But I think she has consent of the other stakeholders. So
No, there is only one appellant here.
Lordship, there is 6 appellant, Lordship. 1, 5, and 6 are the
2, 3, 4 are minor children.
2, 3, 4 are the
1 is the
minor.
wife, 5 is the mother, 6 is the father.
Yes, Lord.
2, 3, 4 are minor.
Yes,
3,
Lord.
4 are minor.
Okay.
One is the wife.
Doesn't matter. 2, 3, 4 are minor, they cannot sign any wakalat now.
Yes, Lord.
Heard. J. Kolita.
Yes.
Heard Ms. J. Kolita, Learned Counsel for the appellants. Also heard. You have filed the affidavit.
No, Lordship.
Why? You are required to file an affidavit.
Lordship, I have taken time, but appellant number 5 and 6 are aged person. They cannot come, Lordship. So that's why it is delayed. Appellant number 5 is the 65 years old, Lordship. Father of the deceased person, and 6 is 62 years. They are residing in Pupri, Lordship.
You should have filed an affidavit. Heard Ms. J. Kolita, learned counsel for the appellants. Full stop. Also heard Sri C.K. S. Barua, learned CGC. Full stop. Para. The present appeal has been preferred under Section 23 of the Railway Claims Tribunal Act 1987 in respect of a judgment and order dated 16/6/2023 passed by the learned Railway Claims Tribunal, Guwahati bench in so and so, number to syllable, OAIUN. While the appellant number 1 is the widow of
Widow,
the
Lordship.
widow of the
What is the
deceased,
disease?
and the appellant numbers 5 and 6
Father and
are the parents of the deceased. Full stop. The appellant numbers 2, 3, and 4 are the minor children of the deceased and are represented by the appellant number 1. Full stop. Para. The grievance raised in this appeal is not against the quantum, but the manner of distribution of the amount granted by the learned tribunal. Full stop. Where is the similar
number-
order?
Page number 21, Lordship.
Similar order.
Similar order, Lordship, page number 25. I have an X. Here are only mother and father, Lordship. This is person, and here is wife with Lord.
By the impugned order, the amount of rupees 8 lakh, which was awarded with interest at the rate of 6%, was directed to be distributed in the following manner. Distributed by breaking the amount into several parts. Full stop. The learned counsel has submitted that such distribution would not meet the ends of justice, as there is immediate requirement for the betterment of the appellants, including the 3 minor children. Full stop. Para. As regards the aspect of the affidavit which was required to be filed, in connection with the purpose for which money was required, the learned counsel has submitted that the appellants, that the appellant number 1, that the appellants being at Dhubri and was not able to come to Guwahati for filing the affidavit, for swearing the affidavit, such affidavit has not been able to be filed. Full stop. The learned counsel has, however, submitted that it is only for the welfare and betterment of the three minor children, that the part of distribution of the amount by the learned tribunal requires some modification. First of para. The learned counsel for the petitioner has also referred to a similar order passed by this court on 36/2023 in MFA 53 of 2023. Para 3 Sarma Barua, learned CGC, does not object in principle to the prayer made. First of, he however submits that the distribution should be made in a manner which will bring maximum benefit to the appellant's claimants, including the three minor children. Yes, what do you propose?
Lordship, my prayer is the entire amount of appellant number 1, 5, and 6 may be released, Lordship.
What about 2, 3, and 4?
Lordship, 2, 3, 4 are the minor children. Lordship, their amount, I have no objection that their part has been fixed.
Okay, okay.
It shall be
How
fixed,
much was
Lordship.
given
Lordship,
for 2, 3, and 4?
Lordship, 3 lakh shall be payable to the wife, but they can release only 2 lakh rupees. Lordship.
No, 2, 3, 4. How many? What amount was fixed?
1,50,000 payable to the minor daughter, Lordship, and 1 lakh for minor son, Lordship.
No, there are
Total
three.
amount-
There are three.
Total amount 4 lakhs shall be fixed, Lordship.
There are three children.
Yes, Lord.
Children, what is the distribution?
Lordship, 1,50,000.
Each.
Yes, Lordship, 1,50,000 each.
Then it will be more
Only
than
2 and 3. only two is-
1.5, 2,
Yes, Lord.
1.5, 3,
Yes, Lordship. Or
and
only
one-
1 lakh for
4.
4.
Okay. Then this will be 4 lakhs.
Yes, Lord.
And mother?
Father 50,000.
No,
mother,
no, the wife, widow?
wife 3,000. 3 lakhs, Lordship.
3. This is 3. And it's 50-50.
Yes, Lord.
Mother, father, 50-50.
Yes, Lord.
Para. After considering the aforesaid aspects, comma, while the direction of the learned tribunal, so far as the amount concerning the appellants numbers 2, 3, and 4 are concerned, are not interfered with. Full stop. However, the amount which has been allotted to the appellant number 1, 5, and 6 are to be released
Yes, Lord.
to them without any further conditions. Full stop. For the sake of clarity, the distribution would be in the following manner. The appellants number 1 is who has been allotted rupees 3 lakhs. No, the amount which has been allotted to the appellant numbers 1, 5, and 6, which are respectively of rupees 3 lakh, rupees 50,000 and rupees 50,000 are to be released to them without any further deductions. The amount of rupees 1.5 lakh each for the appellant numbers 2 and 3 are to be the amount allotted and the manner of depositing the same in a nationalized bank as fixed deposit for the appellants numbers 2, 3, and 4 as contained in directions 1, Roman 1 B, Roman 1 C, Roman 1 D shall, however, remain intact. Full stop. Appeal accordingly stands allowed with the observations made above.
Lordship, kindly mention with interest may be released, Lordship. Appellant number 15, here is 6% interest.
No, it's already there.
Yes, Lordship.
The
Observe.
observation of interest, however, has not been modified and would remain as granted by the learned tribunal.
Obliged.
No, modified bile ko bonala. The observations on the aspect of interest would remain intact. Yes, next. Item number?
My lord, just now I've seen this, the employee state insurance corporate. My name is not reflected.
It will be appearing.
My lord, I'm very,
It's a new matter.
my lord. My lord, there was a IA for consultation. Just control.
24 কি লিখছে তো 2024 কেন 24 হবো?
I mean, there was a IA for condonation of delay, so it was admitted.
Okay.
Condone this.
Okay.
And my name may be shown, my lord, but just now I was going to the cost.
You are you the standing counsel?
My lord.
Okay. Though none had appeared for the appellant on the last occasion, that is 28/2/2024, Sri M. Smith, learned counsel, who was present in the court, has informed that he would appear on behalf of the appellant, being the standing counsel. Full stop. Para. Friday?
I'll need some time to.
Okay.
After application.
On his request, list on 17th of July 2024 by reflecting the name of Sri M. Smith in the cause list for the appellant.
LA appeal, my lord, it was, my lord, Tamil court below, my lord, awarded, my lord, it is up to 90,000, my lord. Initially, it has given 45,000 per bigha, my lord. Similar matter has been already, my lord, admitted and record called for, my lord. I'll add it now. Only, my lord, 45,000 per bigha given, my lord. That's for enhancement.
This is under the earlier act of 1894.
Yes, my lord.
So you have preferred this appeal under 54.
Yes, 54.
Okay.
3 lakhs given recently, my lord, honorable apex court, my lord. I have annexed it.
Okay. House 3 is just learned counsel for the appellant who has preferred this appeal under section 54 of the Land Acquisition Act 1894 in respect of a judgment and order dated 21/12/2019 passed by the learned District Judge Gwalpara in LA, within bracket reference, case number 16 of 2013. Full stop. The learned counsel is aggrieved by the inadequacy of the amount. Full stop. Para. So thus the learned council has also submitted that similar appeals have been admitted, and one of those are, and one of those appeals is LA Appeal 9 of 2024, which was admitted on 27/3/2024. Para, admit, call for the records. Sri.
T.R. Gogoi, Lord.
No, you, Mr. Gogoi, you are a state council.
Lordship, three.
Okay, three. C.K. Sharma Burwal and CGC accepts notice on behalf of respondent 1 and 2, whereas Sri T.R. Gogoi and State Council
Respondent
accepts on behalf of respondent 3.
Lord.
Para, that extra copies of the memo of appeal along with enclosures be served upon them within 2 days. Placed after 6 weeks with report on the receipt of records.
I will let
Martha.
Item 13.
May I please, Lordship? This is an appeal, first appeal, Lordship, against the injunction order. Actually, injunction was granted partially in favor of plaintiff appellant, Lordship. It was granted so far the alienation is concerned, but so far the permanent nature construction is concerned, that is not granted. That's why it is appeal against the partial order granted by the learned courts below you.
You are the plaintiff.
You are the plaintiff, Your Honor. We are the agriculturists actually by profession, Your Honor. Our agriculture farmland hasn't been.
No, you are the plaintiff in the suit.
Yes, plaintiff. We are the
But,
plaintiff.
and suit was for?
Suit was for possessory right, Your Honor, because we are the Khotian holders of the agricultural land, Your Honor, under the original landlord, Your Honor. Original landlords did not contest the suit, Your Honor. Subsequently, some persons, Your Honor, sold away portion of the suit.
The appeal
landlord.
will lie in the court, in this court,
Yes, Lord.
pecuniary.
Yes, pecuniary jurisdiction is there. And that's why, Your Honor,
What is the nature of injunction?
nature of injunction, we had prayed for total prohibition of the permanent nature construction. It was enforced upon almost 2 kotha of land, Your Honor.
Against permanent construction.
Yes, again, permanent construction as well as alienation, Your Honor. Because already they have sold it in their favor, Your Honor. Respondent number
Now,
1
what is
and
the
2.
partial injunction granted?
Partially granted, so far alienation is concerned, further alienation, Your Honor. Already alienation was done, and it is so far the further alienation is concerned, it was prohibited, Your Honor. And so far the permanent nature construction, they are being continued with, Your Honor. Annexer, I have made even annexer also here. I have also made injunction prayer also before this Honorable High Court,
No,
Your Honor.
if you are successful in the suit,
Yes, Lord.
you get the constructions free of cost.
Lord, the thing is that, Your Honor, in my front, Your Honor, my farmland has been enforced upon, Your Honor. That is, certain mafias are involved here. So far the respondent number 3 and 4, they are the power of attorney holders, Your Honor. At their behest, Your Honor, land has been sold out in favor of respondent number 1 and 2. And local administration is also involved. We have filed number of applications before the local administration also. But local administration rather granted sale permission, and they have sold out my farmland, Your Honor. They have already enforced upon, Your Honor. That is the case, Your Honor. Prima facie case is already there. Learned trial court has already held that there is a prima facie case. Lordship may kindly see page number 68 of the impugned order. Page number, it is an extensive order passed by the learned court below, Your Honor. Page number 68, Your Honor, it may be seen, Your Honor. Petitioners have, Lordship may kindly see page
No,
number
you have
68.
given the protection that the suit land would not be alienated.
That is already granted. Your Honor.
That you already have.
Yes, already have, Your Honor.
Your substantive rights are protected. Now, if they make any construction, let them make the
Construction
construction.
in front of me, Your Honor, it is going on, Your Honor. Permanent nature, Lordship may kindly see annexer 8 of the
No,
appeal, Your Honor.
constructions would be subject to the outcome at their risk and cost.
Lordship, my farmland, I have already suffered irreparable loss and injury.
No, if the constructions have already been developed or progressed, your farmland is already destroyed.
Yes, my farmland is already, nature character is already destroyed, Your Honor. That's why I have come before the Honorable High Court, Your Honor. So that the further construction should not be undertaken.
What do you gain?
Lordship think is that whatever is done, that can be dismantled upon, Your Honor.
Even if they make a full house, will dismantle it.
Partly dismantled. If something multi-story building is raised upon, Your Lordship may kindly see the annexer 8, Your Honor. And by the side of the annexer, Your Honor, nature of construction, there is some
We'll issue
building is also
notice.
there.
We'll
There is
issue-
some building is also there, Your Honor.
we'll
They may
issue-
raise such sort of multi-story building also,
we'll issue notice.
enforcing my farmland, Your Honor. It is a peasant's hard-earned property, Your Honor. Peasant is approaching the Honorable High Court, Your Honor, seeking protection of the right.
We'll issue notice here.
Lordship may kindly be granted at least ad interim injunction, Your Honor. So far, the permanent nature
See,
construction.
it's a matter of injunction. Unless we issue notice, it's not a question of passing an ad interim injunction. You have
No.
already been protected by the
So
observation
far,
not
the
to
alienation
alienate.
is alienation
Alienation.
portion, yes. But so far, Lordship, permanent nature is constantly going. I have annexed one
Ultimately, it's a
photograph.
matter of injunction.
Photograph
Injunction,
may kindly be
will-
seen, Lordship.
injunction
Three
without hearing-
photographs are there, Your
without-
Honor. Their
without
henchmen,
hearing-
their henchmen are working under the behest of the local administration, Your Honor. Local police station is also there, Your Honor. They are not helping
See,
me.
they,
They are
court
not
has-
helping me. I have filed FIR also.
Mr. Sharma, a
Yes.
court has applied its mind
Yes, Lord.
and has come to a final conclusion that you are entitled to a protection only for alienation is concerned. You are making a further prayer so far as the construction is concerned. Without issuing notice, we cannot pass any order. ad
Yes,
interim
Lordship.
order.
A short date may be given, Lordship. 2 weeks time may be given. 2 weeks time, Lordship. Landed Court Bureau has held that we have a prima facie case, Lordship.
Heard. Sri H.K. Sharma Learned Counsel for the appellant who by means of this appeal has put to challenge an order dated 7/3/2024 passed by the learned civil judge, senior division, Kamrup, in J case number 81 of 2023, arising out of title suit number 56 of 2023. Full stop. By the aforesaid order, the prayer for injunction has been partly granted. Full stop. Admit. Para, let notice be, let steps be taken for service of notice upon the respondent numbers 1, 2, 3, 4, and 5 be taken by registered post with AD. Steps within 2 days. Mr. Gogoi, Circle Officer, DC, Kamrup and District Commissioner,
Lord. Yes,
Sri T.R. Goel and the State Council accepts notice on behalf of respondent numbers
Respondent
6
number
and 7.
4, 5.
That extra copies of the
I think.
memo will be served upon him.
I think
Full
30.
stop. List on
Short date may be given, Lordship.
list on 17th of July. Full stop. And in the IAU, right? This IA has been filed under order 39, rule 1 and 2, read with section 151 of the Code of Civil Procedure. Praying for ad interim injunction. Para. The connected appeal against the order dated so and so passed by the so and so,
Seven feet.
has been admitted today. Full stop. Para, that notice be issued upon the opposite parties, returnable on 17th of July 2024. Let's steps can huh? Okay, 1, 2, 3, 4, 5 by registered post AD, 6, 7 by Google. Extra copies. Okay.
extra copy should be
Yes,
served of us. And our name should be reflected in the
yes,
as G Assam.
cause this to reflect
Lord.
G Assam
Lord.
in the cause list. No,
Okay.
no, registry to reflect G Assam in the cause list.
We have already served him prior copies on.
He may not be
Your
aware.
Department of Revenue as well as the Learned Township.
He may not be aware. No,
Otherwise, it was not would have been accepted by the registry.
he's not saying that he's not served. He's only saying that his names are to be reflected on the next date. Okay.
Already served for him. Okay.
Okay, next.
Please, your lord. First, this is a appeal just come for the first time. It is against the rejection of my application for appointment of receiver.
Receiver, 41,
Lord, 40.
40. Why do you want a receiver?
Lordship, the respondent number 2 took loan from respondent number 1. And in the meantime, they approached the appellant bank to take over their loan account. We, by letter dated 8/12/2014, paid the entire outstanding amount as per the statement shown to us, that is 87,92,000. In the said letter written by us to UCO Bank, that is respondent number 1, we said in the last line, in case of any
Where is
reason,
your application?
my application is at page,
You're the plaintiff.
I'm the plaintiff, lordship.
It was instituted in 2018.
2019.
18, suit was of 18.
2018, lord.
Yes, where is your application?
Application at page 148.
148. Not 148, 149 perhaps, or what? 149. 149. Yes, what are the preconditions for which are to be taken into consideration before passing an order of under order 40?
Lordship, we have in para number 10. Lordship, may kindly come to para 10 of my application. We have stated that
Application under order 40?
40, Lord.
Yes.
That it is absolutely unknown about the way of maintaining and or handling and or operating the properties. And in particular, the way and mode of operation and or handling of such property for making good or and holding good and utilizing good. So we are anticipating that since last 10 years, we have already paid the amount, mortgage amount to the respondent number 1.
Difficult.
So we don't know about the how it is maintained.
Difficult. Okay, first appeal will admit. Heard Sri G. Khandeli, Learned Counsel for the appellant, who by means of this appeal preferred under order 43, rule 1S of the Code of Civil Procedure, has put to challenge an order dated 5/4/2024 passed by the Learned Civil Judge Senior Division bracket number 2, Kamrup Metro, in petition number 2830 of 2022, arising out of title suit number 404 of 2018. Full stop. The appellant is the plaintiff in the suit, and the application was filed under order 40, rule 1A, read with section 151 of the CPC, for appointment of a receiver. Full stop. By the impugned order, comma, the said prayer has been rejected. Full stop. Para. Admit. Para. Let steps be taken for service of notice upon the respondents be taken by registered post. Registered post with AD.
Sir, I am preparing for the UCO Bank. Sir.
Oh, UCO Bank. Okay, very good. Sri Sen, BK Sen,
Hello.
Learned Counsel, appears for the respondent, appears and accepts notice on behalf of the respondent number 1. Let steps be taken for service of notice upon the respondents 2, 3, 4, and 5.
Lordship, 5 will not be necessary in this application.
to three, the four by registered post with AD. Para, list on 17th of July for service report as well as appearance.
Extra copy में extra
Yes. The this court will consider as to whether notice would be required to be issued to the pro forma respondent number 5 on the next date. Yes, give an extra copy.
Much obliged.
But my name will be shown in the court.
Now you file a local number. Unless you file local number, you cannot. There is no standing counsel.
Obliged.
Vacation বলে কি কইছিল? Vacation. It was no submits that he would accept notice. Huh? এটা ওকালত নাম্বাৰ বুলি এটা লিখি থৈ দিয়াচোন মই পিছত মনত কৰিব ওকালত নাম্বাৰ দিব লাগে বুলি মোৰ ইয়াতে উলিয়াই দিবা yes
I have been filed for
item number
15 for condemnation of delay ballot for 186 days. But due to inverters,
yes who is for the respondent
for respond number 1 the name has been shown my lord. 2 and 3 I was directed to take steps best as market. Sorry, man, due to inverters can't be taken, man, I'll take step by step.
2 and 3 okay
Respond number 1 the name has been shown now.
Now it appears that the counsel who was appearing for respondent number 1 has passed away.
My lord.
There you can inform any of his chamber juniors
My
if
lord.
they are willing to. I don't think Mr.
Oh, my
Thakuria.
lord, in that case, my lord, if the fresh the steps may be
Yes.
upon all, that will be best.
Yes. Hertz 3 M. Smith Learned Counsel for the applicant. Full stop. Though the respondent number 1 had entered appearance, comma, the applicant appellant was directed to take fresh steps for respondents 2 and 3. Full stop. Para. It, however, appears that the leading counsel whose name is appearing in the cause list as counsel for the respondent number 1 has passed away. Full stop. Under the aforesaid facts and circumstances, comma, let fresh steps be taken upon all the respondents.
Well, all the
Para. Or respondents by registered post with AD.
Well.
Steps within 3 days.
Well.
List on list on 19th of July
Well.
along with service report.
Item 17.
It is your lordship, affidavit regarding service of notice by trustee could not be filed by the petitioners because they haven't returned the notice which we had sent you. We have instructions that he is seriously ill.
The dusty was upon whom?
Respondent number 5.
Mr. Gogoi, you are
Okay,
for?
I am for respondent 1, 3, 7, and 14 to 17.
But have you taken dusty?
We had sent him the notice which was issued by the registry, but he is seriously unwell. So he
Oh, you
couldn't-
have not been able to serve also.
Also, we have received the instruction that that person has left and he has a new address. We may be allowed to take dusty of the new address.
Where is the order for dusty?
Your lordship, order dated 23/8/2023.
23/8/2023.
2023. Yes, your lordship.
23. What is? 23, 8. This matter was last listed on 9/2/2022.
Your lordship, it had come before Lavazima.
Lazima cannot allow you to serve Dusty.
I- Your lordship, order dated 09/02/2020.
Okay, let us not go into this controversy. What is your name?
Yes, Nevar.
S.
Nevar.
Never, okay. Heard Miss S. Never, learned counsel for the petitioner who submits that due to certain unavoidable circumstance, comma, steps by Dusty have not been able to be taken. And she taken so far as respondent number
5.
5 is concerned. You appear for Mr. Gogoi for all the other respondents.
I am not for all, I am for respondent number 1.
And what about the others?
Your lordship, they have entered appeal.
No, he's not for all.
I am for 1, 3, 7, 14, 15, 16, 17.
They have filed Wakalat Nama.
There are other councils names
I have
appearing.
not had- I file only for this. 1, 3, 7, 14, 15, 16, 17.
Who is Mr. K. Brook with you?
Yeah.
Then there are other council also, other parties also, madam. How do you?
Your lordship,
There are 23 numbers of respondents.
Your lordship, office note dated 02/05/2022 reveals that notice has been issued on respondent number 1, 2, 5, 7, 16, and 21. And process server has been received back. The service is.
Okay, let us not go into the respective. Ki kolo etu? As- Five is concerned. She accordingly prays for another opportunity to serve Dusty upon the said respondent number 5, as his address has also changed in the meantime. Full stop para. Sri N.J. Gogoi, learned counsel, is present for respondent numbers
1, 3,
1, 3,
7,
7,
14,
14,
15, 16, and 17.
15, 16, and 17. Para. The learned counsel for the petitioner is permitted to serve notice by Dusty upon the respondent number 5. And such Dusty is to be routed through the registry of this court. Full stop. Let the next date be fixed on 22nd of July, 2024. And the said date is to be clearly reflected in the notice accompanying the Dusty. Full stop. It is also observed that in view of the submissions made, that there is change in the address of the respondent number 5, comma, the correct address may be given by the learned counsel in the Dusty notice. Full stop. The petitioner is also required to file an affidavit prior to the next date fixed in proof of such Dusty service.
Obliged.
We're fixing when? 22nd.
22nd.
You file affidavit before 22nd.
18.
For this matter, I am appearing, Lord, to file it or response, my Lord.
You're appearing as CDC.
Yes, my Lord.
Yes. What is this?
Lord, we'll file our response, my Lord.
You'll file your, what is this MFA?
Lord, it has challenged the order passed by the RCT, my Lord, the Railway Claims Tribunal.
What response will you file? Take instructions, make your
My
submission.
Lord, I'll take inspection.
We are not, there is no question of any pleadings.
My Lord.
We'll go by LCR, what is the,
my lord,
LCR has come, madam.
Yes, Lordship.
Thanks.
Lordship, in this matter is squarely covered by one recent judgment passed by the Honorable Justice Parthisuti Soikia, sir, on 9/4/2024.
What is the,
Lordship.
what is the issue involved?
Lordship, issue regarding terminal charge. Lordship, this matter kindly fix a short date for early disposal.
Okay, we'll do it. Your name, madam?
M. Kolita.
Ms. M. Kolita, Learned Counsel for the appellant has submitted that the issue has been resolved by a recent judgment by a coordinate bench, of a coordinate bench, full stop para. Sri H. Gupta, Learned CGC, praised for some time to examine the aforesaid aspect, full stop para. List on when, madam?
18th of
Okay, not 18th, 18th, okay, 18th, 18th. If it's covered 2019, 18th of July.
July.
Still awaited, no.
Which order?
My lord, 18 to 2020.
It will come from which place?
Look, Kamrup Metro, Lordship.
There's the office note, Lordship. for
What is the matter about? You are praying for enhancement.
Enhancement, my lord.
Based on what?
Just the observation, the consideration of the amount, my lord. Basically,
No, your enhancement is based on what? Madam Chaudhary, if we can decide this matter without the records, we'll decide it.
Lordship, it's a injury case, Lordship, that papers is prepared. Disability
medical
certificate
certificate,
and all.
I'm trying to refer. my lord.
Now, are you
Basically,
relying upon those
Yes.
documents?
Yes, Lordship, I'm relying on those documents.
Therefore, it is
Because I'm referring to the medical certificate, which was not taken into consideration for considering my 55% of disability that I'm.
The
therefore-
medical certificate, was it proved?
Yes, my lord.
It was proved,
Yes,
As
it was all
exhibit?
enclosed, lord. It was all enclosed in the.
not enclosed. Was it proved or not?
Yes, Lord, it was all proved.
Proved as annexure, affidavit, exhibit
Exhibit 8,
8.
yes, Lord.
And what is the finding on exhibit 8?
My lord,
you said
here
that-
I was. able
You
to-
said that that has not been taken into consideration in the proper perspective.
Yes, Lord.
What is the finding?
Finding is a page 13, Lordship, with the original copies of documents are not available on the record. They have not found original or all are photocopies.
Photocopies.
Therefore, Lordship, it is medical treatment was awarded as 3 lakhs rupees, non-pecuniary compensation 1 lakh, pain and sufferings 50,000, totaling rupees 4 lakhs 50,000. Documents are not there.
Injury case.
Injury, Lord.
What was the nature of the injury, Mr. Vishwakarma?
I was physically handicapped, this is what I have referred.
No,
it.
what injuries did you sustain? Where?
In the lower limb of my body, in the lower limb. I was
Okay.
bedridden condition almost for a year.
Thereafter,
Thereafter, Lordship,
were you examined by a board?
Lord, as far as the exhibit which I was relying on, my lord, is a physically handicapped certificate. which
That
was
is it
issued
by a board?
back to verify.
Madam,
Lordship, no.
is it by a board?
No,
Then
Lordship. Dr. Gautam Majumdar, private doctor, Lord.
no, that will not suffice.
Record will Lordship is Lordship.
No, see, records were called for many times, and if the records do not come, we will not.
No, Lordship.
No,
Yes,
Lordship.
no, Lordship. Here, the law court record has not been received as yet. That is official dated 14/6/24, Lordship.
No,
The thing is that earlier, Lordship, we have paid the amount immediately after the judgment, Lordship. But they have filed an IA petition, Lordship, for release of the awarded amount. Therefore, law court record was sent to the MSCT again, Lord. It came once, Lord.
it had come once.
Yes,
Lord.
yes. That is, Lordship will find IA 1620/2020. Order dated 18/2/21.
And office note 5321, it is reflected. Once
Now, when was the LCR again called?
it was again called on,
It was not.
Was it called again?
yes, Lordship, it was called again.
You tried in the Lok Adalat,
Yes, Lordship. But
not able to be settled. Why?
because documents are not there, Lordship, on the basis of that, they are not agreed to that.
Though the LCR were called for and received, comma, those were sent back in connection with an order passed in the connected IA.
Yes,
Yeah.
Lord.
Full stop. The said LCR were again called for, which are yet to be received. Full stop. Office note dated 14/6/2024 is on that aspect. Full stop. Para registry to issue immediate reminder for the LCR. Full stop. List this case immediately after the summer vacations, not immediately, after the summer vacations, along with the
Can
LCR.
it be on first week of August, Lordship? I'll talk.
Okay, in the
Immediate.
first week of August, along with the LCR.
Must apply.
I oblige.
May I please the lordship? The matter is ready for hearing, your lordship, as regards records and appearance of the other
Records
party.
have come.
Records have come.
It's for orders or admission or what?
It's for
Admitted,
hearing, my lord.
admitted for hearing.
Hearing, my lord.
Yes, if you are willing, you can make your submissions. We'll hear you.
But perhaps after vacation, my lord, in the last week of July, my lord.
What is this? You are the husband.
I'm the husband, my lord. I filed a divorce petition.
That has been rejected.
It was rejected, my lord. And
What are your grounds?
desertion and cruelty, my lord,
And the findings in both the counts are against you.
against me, my lord. They have been negative, my lord.
Till how many, what is the period of your
Separation, my lord.
separation?
We separated on 28/8/2006, your lordship.
Okay, and
So it's almost
what is
18.
the finding on the issue of animus deserendi?
The animus deserendi, your lordship, will kindly come to page 57.
37,
Page 57, my lord.
57.
57, my lord. Last paragraph.
Yes.
The other ground, this is desertion, on which the petitioner further relied to seek the relevant relief in the instant case, also does not appear to be sustainable in the light of the relevant materials on record. The materials on record, as being brought by the petitioner, reveals that the respondent left for her paternal home after the petitioner already left for Buxa, leaving her and their daughter at Badarpur, which suggests otherwise. This is the petitioner to have deserted her.
Hmm.
Now, your lordship, the petitioner was a police officer, my lord. He's retired, my lord.
Thereafter,
It appears that the petitioner clearly brought the fact that immediately after being released from jail, he got transferred to Buxa, and accordingly he left for Buxa without taking respondent. It appears that though he stated that he tried to bring the respondent to Buxa, but she refused, but to substantiate the said fact, failed to adduce any cogent evidence. It is worthwhile to mention that even if it is believed that the respondent left the petitioner, then also in light of the facts being duly proved by the respondent against the petitioner, duly establishes cogent cause, reason for the same. In view of the foregoing discussions, this court is of the opinion that the petitioner
okay,
failed to.
okay. You are a government servant
I'm a government servant, my lord.
Retired?
Retired, my lord.
and you left Badarpur why on being transferred.
On being transferred, your lord.
You are in the jail.
I was in jail. She filed a 498 case against me, my lord.
Oh, no, you are inside the jail as an accused.
My wife filed the case against me.
Oh,
my lord.
that is it.
That was withdrawn. That was withdrawn by the wife.
No, we thought that you were employed in the jail.
No,
You
no,
were,
I
you
was
were,
police officer, my lord.
but you were arrested.
I was arrested.
That you were released from the jail and you got transferred.
I was transferred to Paksa, my lord. I was in Karimganj, then I was transferred to Paksa, my lord. After, my lord, I was released from judicial custody, my lord. I went back to my in-laws' home, my lord, tried to reconcile and tried to take her with me to Baksa, my lord, but she refused. my
Mr.
lord.
Dhar, the findings on desertion, what do you have to say on this?
My lord, this is something factually, this is not my instruction. In fact, she is willing to live with him and he is not coming. And they have a daughter now presently 18 years old. So,
No, it is not a case of restitution that
yes,
you give an offer that yes, I am willing. He is filed for divorce.
he has filed and there was, although he had an earlier wife and when I filed in 498.
Parties are Hindus or Muslims?
Hindus.
Hindus.
Earlier wife means
Earlier wife, deceased wife.
deceased wife.
Deceased wife. He had a son out of that. And I got married to, he got married to me just to look after the son.
Okay.
That was done. But after a few days, the son went missing. Then I got a child, daughter, and he started cruelty. And with there are some other things also. There is he had.
No, we are not hearing it in the length. But you did not file for divorce.
No.
He filed for
He filed.
divorce on the grounds of cruelty and desertion.
Yes.
The discussion on desertion, I think it's not adequate.
The ingredients of animus, my lord, is there, my lord. I can show it to your lordship. And the criminal case, my lord, I have got an
And
acquittal.
your intention
Yes.
that you are not, you do not intend to stay away from him.
Yes.
Rather, you want to come. That is not reflected here.
Yes, pilot. But
And from 2006, if you are living separately,
yes,
and
pilot.
there is no intention on the part of the opposite party to stay together.
Lordship will just have a look.
Okay,
at the
we'll fix a date. What is your age?
My lord, I'm 63, my lord. Present 64, my lord.
How old is your daughter?
18 years present.
18.
18.
Student.
I have been paying maintenance since 2006, my lord.
You stay where?
I'm presently in Tinsukia.
You are in Tinsukia. And you are at Karimganj. This divorce was instituted initially at Tinsukia.
At Karimganj.
Karimganj.
You had instituted okay. There was no transfer to Karimganj. You had instituted Karimganj itself.
Karimganj,
Okay.
because she resides there, my lord.
Okay. List for hearing on 24-1. Though this matter was directed to be listed for, it is from a
Division bench.
division bench.
Yes.
It's from a family court.
No, it's from district.
District judge, my lord.
But then before a single bench.
Single bench, my lord.
Why it had gone before DB?
Earlier, that notification was not there.
Okay. Though there was an order for listing of this matter for hearing, this has come up for orders today.
Order, sir.
It came by order.
It has come off under the order column, order to inverted comma. What's the para? List for hearing when?
Hello, any day.
Last week,
List
July.
for hearing in the last week of July 2024.
Highly obliged, my lord.
Obliged.
Lordship, the FCR has come to fix the matter for hearing
Here for whom?
applicant. Applicant,
Applicant. Applicant or what? What is this? An application or an appeal?
applicant,
Appellant. Okay, madam, you for?
For the sole respondent, my lord.
Records have come.
Yes, lordship.
We'll have it for hearing.
Yes, lordship, this matter also query covered by a judgment passed by you, lordship.
On the aspect of what?
On this matter regarding punitive charges for overloading, it's a matter scheduled
Okay.
to appeal under
Uh,
section 23 of the
okay.
Legislation.
The matter is ready for hearing, is ripe for hearing. And LCR, as LCR has also been received full subpara, please for hearing immediately after the summer vacations. Yes.
Maybe 6
What is the shortest date?
of
We have said immediately after the summer vacations.
Oblige, your
Please, your lordship. Lordship, IS civil number 49 of 24 has been filed for substitution of legal heirs of the deceased respondent.
IA number
49 of 20.
49. What 49? Okay. Death certificate,
I have got a copy of.
you are directed to have it
File.
on record.
I may be allowed to file it, but on the last occasion, Lordship, on the last occasion, the respondent side appeared and submitted that they have no objection if the substitution is
Who is
allowed.
for the respondent?
Mr. R. Talukdar.
H. Talukdar. L. Talukdar.
L.
Yes, who's for the respondents? L. Talukdar, B. Das, K. Kulita. You know them?
Yes.
Can you inform them?
Yes.
We'll allow this then, okay? You have an extra copy of this?
Yes.
Okay. We'll have it after some time. You will just try to inform them.
Okay.
Otherwise, we'll fix a date, but we'll try to finish up the IA today itself.
Yes, yes. Okay.
This service is completed and ICAR has also come.
What is the IA for? Stay. Can, you are for the respondents?
I am for the respondent number 1.
What about the others?
I'm also appealed.
F Intaz, 2 and 3, they have also appeared. Names are there. Yes. LCR, he said, no? The appeal is ripe for hearing. List. Accordingly, list for hearing. When?
Vacation, what date may be given?
Immediately after the vacation, summer vacation. Okay. Next.
It is your lordship, your office note dated 6/6/24 says respondent 1 and 3 file wakalat. Now for 2, it has not yet been received back. LCR received. Okay, we have taken steps on 31/7/23 itself. So it can be deemed served, lordship, so wishes. Or we have to await, lordship.
My lord, the order of the 6/28/6/23 has not been complied. Because they are supposed to deposit 50% of the amount. Today I verified from the registry, it was not, because it is subject to the deposit of this appeal will be accepted.
No,
Specifically,
I've already informed them, lordship, last year in July, it says 19/7. I'll have to check the record.
I have, today in the morning, I have verified, my lord, they have not yet
The
deposited.
record to check. Lordship, then I'll have to take him because last year itself I had given the.
Madam, here in this case, the admission is subject to deposit.
True. So, Lordship, actually, I have my letter also, which they have received. So I
Okay,
will
then,
verify,
okay,
maybe
okay,
inadvertent mistake or something like that.
okay. Mr. Bhattacharya, you are for which respondent?
Respondent number one.
Sri K. Bhattacharya, Learned Counsel for respondent number one submits that the appeal was admitted subject to deposit of half of the awarded amount before the registry of this court, which however has not been done. Full stop para. Ms. R.D. Mazumdar, Learned Counsel for the appellant, however, submits that instructions for deposit, for making the deposit was made long time back and therefore,
1970.
she prays for some time to obtain necessary instructions. Full stop. Para, list immediately after the vacation.
Highly obliged.
Item 25.
Yes, Mr. Mazumdar, what is this?
Item 25.
20?
25.
Yes.
May I tell you, Your Lordship, it is for condonation of delay of 104 days.
This is a delay condemnation application. Okay. Yes,
My lord, I have filed my objections, my lord.
you have filed.
Okay.
Yes.
Lordship, I have explained, Lordship, page, paragraph 2, 3 and 4, Lord. My Lordship, she got the information regarding the Lordship, judgment, Lordship, on Lordship 28/2/2023, Lord.
This appeal is against what?
Against Lordship, this is the degree of divorce, Lordship, and the degree was passed ex parte, Lord.
You did not file order 9 rule 13.
Lordship, Lord.
You had filed straight away appeal or what?
Lordship, she got the information regarding the,
No, did you apply for setting aside ex parte? No.
oh, Lord.
This appeal is against the original decree or against any orders passed under order 9 rule 13?
Original degree, Lord.
Original decree. Oh, you did not take recourse to order 9 rule 13. Okay, doesn't matter. You can. And this delay of 104 days.
Lord.
Okay. Divorce has been granted.
Granted.
Yes,
Your lordship,
you are the husband.
I'm the husband.
Yes,
Your lordship will peruse my objections, my lord.
yes, please, yes, let us see.
Page number
What have
19.
you stated?
Page number 19 is the notice summons issued by the trial court. That was served upon the wife, the appellant here, Krishna here, on 25/8/2022, with the endorsement by the process server, my lord, that the aforesaid person named in the
No,
notice.
you are on the aspect of summons.
summons,
He is
sir.
not filed an order 9 rule 13.
Yes.
He is trying to make out some grounds why he was prevented by sufficient reasons in filing, preferring the appeal on time.
Yes, my lord.
You need not go back to the issue of summons. From the date of the judgment till the date of filing, there is 104 days delay.
My lord.
His explanation on those 104 days you can address.
In para 3, my lord, he has stated the applicant begs to state that after going through the certified copies of the documents so and so, the applicant came to know that on 22/12/2021, the opposite party filed a petition before the district judge Karimganj with false and concocted story praying for dissolution of marriage by a decree of divorce on grounds so and so. In the case record, thereafter, my lord, it was found that someone was issued to the appellant and same was returned with a report dated 25/8/2022 that the appellant refused to receive the same. And accordingly, someone was hanged on the door of her dwelling house. But in fact, nobody went to the parental house of the appellant to serve someone. Otherwise, she definitely accepted the same and faced the trial. This is a false submission, my lord. They had notice of the case, they did not contest, they stayed at the house, my lord.
How do you substantiate your submission that they had notice?
Your lordship will come to page 21, my lord.
Yes.
That is the process service endorsement, my lord.
What did he say?
It says, my lord, if I may read the translated
Please,
version.
please.
To the honorable judge, it is humbly stated that today, 25/8/2022, upon inquiry, I reached the residence of the aforesaid person, being the appellant, named in the notice at 2 p.m. And having found present, I explained the contents of the notice. And in spite of repeated requests to accept the same by signing it, but she refused to do the same by signing it, so I hanged the same at the door of her house. Thereafter, there is a verification by the process server, my lord. If he is aggrieved by that, my lord, he could have filed an application under Order 5, cross-examining the process server, my lord. Neither he has filed an application under Order 9, Rule 13, neither he has filed any application under Order 5 to cross-examine.
No, when does he file such an application? If he appears,
Only appeared.
he has not appeared. So that
Straight away he has
eventuality,
come
that
before the-
occasion has not arisen.
Straight away, he has come before the
He
honorable
has
court.
come before this, and there
Making
he
false
can
assertions, my
come.
lord.
He can come.
And
Mr.
there-
Chaudhary for whom? Huh? No, you are same party. Okay.
There's one more aspect, my lord.
You are the wife.
Yes, lordship. The statement of the process server is also not correct, lordship, because there are some other members in our lordship house. He may serve the notice to him
Okay,
also, lordship.
okay.
It's fine.
Heard.
My lord, there is one more aspect, one more submission, my lord. The judgment, ex parte judgment was passed on 3/11/2022, my lord, and limitation period expired on 1/2/2023, my lord.
Hmm.
I got remarried, my lord. I got remarried on 15/3/2023, after the limitation period expired, my lord. Section 15 of the Hindu Marriage Act, my lord, if I may read, my lord.
No, that is okay. We are not finding fault with your remarriage. We are not finding fault with your remarriage.
I will
That-
submit, my lord, on account of my second marriage, my lord, after the granting of the expiry decree and expiration of the limitation period, my lord, this appeal has become infructuous, my lord.
Not
No,
infructuous. We cannot extinguish the right to have the matter adjudicated. What you have done in the form of a remarriage is permitted by law. You have done.
Yes.
That will be taken care of at the appropriate time. If you are not incapacitated by law at the time of your second marriage,
My lord.
then no fault can be attributed. The incapacity will come only when you are marrying during the subsistence of a marriage
My lord.
and the lifetime of the spouse, which you have not done. There was no spouse. You were armed with a decree. Okay. You are AMS
Lord.
Mazumdar.
Lord.
Heard three. AMS Mazumdar, Learned Counsel for the applicant. Oh, your name?
HK Buroma.
Also heard three HK Barua, Learned Counsel for the sole opposite party. What's the para? The instant application has been filed under Section 5 of the Limitation Act 1963 for condonation of delay of 104 days in preferring the connected mat appeal. Full stop. The appeal has been preferred against a against an ex parte judgment and decree dated 3/11/2022, passed by the learned district judge Karimganj in title suit within bracket divorce number 131 of 2021, by which full stop. Para. It is submitted by the learned counsel for the applicant that that summons were not served upon her, as a result of which the applicant was not aware of the proceeding and therefore could not contest the same. Full stop. It is also submitted that she could learn about the judgment at a later point of time and thereafter had preferred this appeal. And in the process, there was a delay of 104 days, as mentioned above. Full stop. It is submitted that there were sufficient cause which had prevented the applicant from preferring the appeal within the time prescribed by limitation. And accordingly, the present petition be allowed. Full stop. Per contra, comma, Sri Barua, the learned counsel for the opposite party, has submitted that the projection of not issuing summons, projection of non-receipt of summons is not factually correct and is belied by the report of the Jari Karak, as per which the summons were refused to be accepted by the applicant. Full stop. The learned counsel has also submitted that after expiry of the period of limitation, comma,
On 1/2/2023.
after expiry, comma, the opposite party has remarried. Full stop. Para. The rival submissions have been duly considered. Full stop. Para. An adjudication in an application filed for condonation of delay is to be done by having a justice-oriented approach and in a pragmatic manner. Full stop. In the instant case, comma, the decree of divorce is sought to be challenged by way of an appeal, and the reason cited is lack of knowledge about the proceedings before the learned district judge. Full stop. It is not in dispute that the judgment is an ex parte one. Full stop. Para. Though there may be certain issues as to whether summons were actually served upon the applicant, comma, this court is of the view that without even going to the said issue, comma, the applicant should not be precluded from a hearing, from an opportunity to challenge the judgment on merits for which the connected appeal has been preferred. Full stop. Para. Considering the above, comma, the delay of 104 days in preferring the connected mat appeal is condoned and this IA is allowed. Full stop. In the mat appeal, you write, while an order passed today, that is so and so, the connected IA civil 1642 of 2023 for condonation of delay has been allowed. Full stop. Appeal may be registered. Appeal is directed to be registered and listed for admission immediately after the vacation.
Copy of the matrimonial appeal may be served upon.
Yes, please serve. A copy of the memo of appeal along with enclosures may be served to Sri Barua, learned counsel for the respondent.
Marshal. Highly appreciate.
22.
Lordship, I contacted the learned senior counsel. He informed that he is out of state, isn't belong for a month.
Okay, we'll have it on Friday.
Yes, sir.
What is your name, madam?
B. Rai.
B. Rai.
B.
V, okay. Though Ms. V. Rai, learned counsel, for the petitioner is present, comma, none appears for the respondent, full stop, para. In the interest of justice, let the consideration of the matter be deferred to Friday.
DPR.
List on Friday. Yes,
My
Mr.
lord,
Gupta.
an appeal against the order passed by the workmen's compensation, my lord. IA is pending, my lord, for condonation of delay. Of, my lord,
How many days?
it is,
You,
500
the appellant, who is the appellant?
we are the appeal.
No, who?
Union of India, my lord, railway.
Railways, okay.
Railways have filed the
Okay.
appeal.
How much is the delay?
My lord, 504 days, my lord.
504
And
days.
also they have filed an application, my lord, by the other side, my lord, praying for deposit of 50% of the compensation amount.
Yes,
Lord, that can be done, my lord. We have already prepared it up.
okay.
Can be deposited with the registry, my lord. Appeal can be heard.
Yes, delay condemnation?
Really, they have not filed any objection.
My lord, perhaps before considering the delay question, my lord, the appeal has been filed not as per the provisions of law. The appeal has been filed under section 30 of the ECA. In that act, my lord,
We will not go to the merits of the appeal. You still have the rights to object on the admission of the appeal.
my lord. My
Right
lord,
now, you can make your submissions on the delay condemnation.
Right.
Only after condemnation of delay, the consideration of the appeal may come.
Right.
You need not address at this stage on the, how the appeal has been presented.
Right.
That you have the liberty at the time of consideration. On the delay, do you have anything to say? We condone the delay and we direct him to deposit 50%.
50%.
Is it okay?
my lord, the provision says, my lord, they have to deposit the full amount before the commissioner.
Commissioner,
And
correct?
certificate has to obtain, and that
Yes.
certificate will accompany the appealment.
Yes.
That is the provision of law. That's what I wanted to.
That is the provision of law, but what is the, who are you? The owner? Is it, are you the insurance company?
No, my lord, they are the victim's mother and father, my lord. So who has
No. Was it insured? No.
No,
There is no insurance
no
company.
insurance company.
No question of insurance, my lord.
Then, some observations made by this court is only in respect of insurance company where they are exempted.
Yes.
You have to deposit and
No.
not here in the WC.
Before the commissioner.
Have a certificate,
Yes.
No,
accompany it in the memo of appeal.
Right.
Mr. Rushid is right.
no.
There is no change in section 30, whether you change the name of the statute or not.
That also.
And
looking at
even
it.
for insurance, but because of a judgment of this court
No.
and also some other judgments that though the insurance company steps into the shoes,
No,
they may not be saddled with the liability to pay 100%. So there are little bit of flexibility, but
No.
for you, that may not be there.
But that provision also that I was examining, my lord.
Section 30 is very clear.
Third proviso of section 30.
You instruct your clients,
No.
we can condone this delay
My lord.
and make that observation. That
No.
you fulfill the requirement and will admit this.
Yes.
Okay.
And I'll take.
Okay. Heard. Shri H. Gupta, Learned Counsel, for the applicant who by means of this application filed under section 5 of the Limitation Act 1963 has prayed for condonation of delay of 482 days in preferring the appeal against the judgment and order dated 7/2/2022 in WC case number 7 of 2018 passed by the Learned Commissioner, Employees Commission, Employees Compensation. Borbeta?
Borbeta.
Borbeta. Full stop. Why, what reasons?
Appeal, my lord. My lord,
No, the delay.
my lord, delay, my lord, due to the records were sought from my lord, the council below, my lord, and legal opinion was
How much is
obtained.
the amount?
Amount is, my lord, 9 lakhs.
For death,
Yes, my lord. 9,27,960.
that case.
Yes,
That,
that's key.
What was he doing?
my lord, he was, my lord, working, it is stated that he has been working as a laborer. But his age was 17 years, my lord, and there is no record of the fact that he was working under the railway. Maybe it was a case of an accident, my lord, not. So the workman's compensation has awarded it on the ground that he was an employee, workman of the railway,
Yes.
whereas there is no document.
You are questioning the employee-employer relationship.
He was not the workman, yes, my lord.
You are questioning that.
Yes.
You said that there is no such relationship.
Yes, and that too, he was at 17 years of age, my lord, minor, so
He could not have
he
been.
could not have been employed as a workman under the railway. That is the basic thing.
Yes, what do you say, Mr. Mullah?
My lord, if you have stated the ground for condoning the delay in paragraph 4 and 5. But my lord, after going through this, both these paragraphs, I don't find that any ground they have stated. My lord, this condonation petition has been filed under section 5 of the Limitation Act. And section 5 of the Limitation Act, your lordship knows, the ground should be sufficient. Here, my lord, let's speak about sufficient ground. No ground has been explained by them, only the official communication they have stated. No ground has been
You are
given. My
record.
lord, sufficient ground
Okay,
means
yes.
basically.
Yes. Huh? Equal. Full stop. Sri Gupta, the learned counsel, has submitted, by learned counsel by referring to the averments made in the petition, has submitted that due to certain office formalities, the delay has occasioned, which is not intentional. Full stop. Para. Sri Rashid, the learned counsel for the opposite party, has however submitted that the grounds cited are not sufficient and therefore the delay is not liable and therefore the application is liable to be dismissed. Full stop. Para. A perusal of the averments made in the petition would show that the delay has occasioned due to certain office formalities. Full stop. The reasons are not specific and do not inspire confidence. Full stop. At the same time, comma, the right to prefer an appeal cannot be precluded, cannot be held to be extinguished because of technicalities. Full stop. Para. In view of the aforesaid facts and circumstances, comma, this court is of the opinion that interest of justice would be served if the delay is condoned. Full stop. However, condoned. Full stop. However, with certain conditions. Full stop. Accordingly, the delay of 482 days in preferring the connected appeal is condoned, subject to payment of cost of rupees 5,000 to 5,000. Full stop. The cost is to be deposited in the name of so and so, but I accordingly stands allowed in the main appeal, you write. The IA 2897 of 2023 filed for condonation of delay has been allowed today that is so and so. Para. Shri Rushid, the learned counsel, who has entered appearance for the respondent has however submitted that the appeal has not been preferred by following the requirements of law under section 30 of the Employees Compensation Act, within bracket erstwhile Workmen Compensation Act. Full stop. Para. Sri Gupta, the learned CGC, appearing for the appellant, would take necessary instructions. Full stop. List immediately after the vacation.
Item 27.
Yes, cross objection.
Yes, your lordship.
Lordship, I have not received the copy.
I will serve.
Lordship, I picked the
The,
matter.
the appeal is by you, insurance company.
Lord.
You are paying for enhancement.
Yes.
Okay. Please serve her a copy. When can we have it?
On 26th
26th.
June,
These are fresh matters. We can have it on 26th.
Lordship.
Okay.
Then Lordship.
Sri Mandal, D. Mandal and Council for the cross objector undertakes to serve a copy of this cross objection upon Miss M. Chaudhary, Learned Counsel for the opposite party insurance company, which is the original appellant in the connected MSC Appeal 691 of 2022. Para. List on, as agreed, as requested, list on 26th
of June.
Your lordship, another appeal 61822 arising out of the same accident may be listed together.
Okay, 22. List, list along with MSC Appeal
618.
16 matter 2022, which is said to have arisen from the same judgment and award of the MSCT.
Same accident.
Or same accident.
Judgment and award is also same. Common judgment. and
From the common judgment and award by the MSCT.
award. Highly obliged.
Item 28.
Yes, what is this?
My lord, this is against the order of maintenance. Wherein, my lord, 45% of my income has been awarded as maintenance. In this, I have already, my lord, submitted my, both sides has submitted assets and liabilities affidavit.
You are the husband or the wife?
I am husband. And page 31 of my appeal.
Petitioner is the husband.
Yes,
The proceeding was for maintenance.
yes,
Where?
24, Tezpur, man.
Tezpur, district,
civil court.
CJM,
Yes, civil court. District court,
district court under what section?
24
24.
of Hindu Marriage Act.
Then,
Yes.
yes. What do you do?
Well, I am cloth shop. I generally sell my clothes at Hart Market, weekly Hart Market. And from the town committee, I have got one top 8x6, and I keep all my clothes there. And generally sell at weekly market. I have submitted my income tax return acknowledgement, page 31, your lordship. 31, 32, and 33.
Yes.
3 relevant years, which is required as per Supreme Court guideline. Yearly income.
Yes.
Accordingly, my income stands 30,000 to 31,000 per month. And 15,000 has been awarded for maintenance. My old pants is also depending on me.
You have old parents.
Yes, my lord.
You have parents.
Yes. Earlier, my parents also one shop, but nowadays.
Wife is working.
Yes, my lord. She is not working, but she is more qualified than me.
Oh, no, is she working?
No.
And any issues?
Instead.
No issue.
Instead.
Son,
Yes.
stays with
Age is
son stays with mother.
mother.
How old is the son?
3 years.
And are you paying separate maintenance for the son?
I'm ready to give the maintenance.
No, are you paying separate maintenance for the son? No.
No. After the order, I am paying every month 5,000 and 30,000 cost I've already paid.
No, you are directed to pay 15,000.
15,000.
You are paying.
Yeah, no, 15,000 I could not pay. Because my earning is 30,000. My old pants is also depending on
No,
me.
but your son is also with your
Yes.
wife.
So my son is I may be awarded to some my lord this amount which I can afford.
How much? According to you?
7,000.
Huh?
7,000.
7,000.
Yes.
So where does he stay?
They are staying with parents at Tezpur.
Your wife is staying with her parents.
Yes.
Where in Tezpur?
Tezpur.
What is the income of the parents? What is their source?
Ration shop, so far I know. Ration shop.
7,500.
If I pay more than that, then I cannot look after my old parents. That is difficult.
Now, how much are you paying for the son?
5,000 and 2,500 is 7,500.
2,500 only for the son.
More than that, yeah.
2,500 is absolutely nothing.
Yes, nowadays.
And 5,000 for the wife. 10,000. Mr. Ganguly?
First of all, this appeal itself is not maintainable. It's against the interlocutory order. He has filed it under section 19 of the Family Courts Act. Overwhelming view of the high courts of our country is that
This is
appeal not maintainable.
the initial 24 petition was adjudicated by whom?
By the additional district.
By the?
Additional district.
Not as family court.
Not as-
Then?
And even otherwise, it's an interlocutory order.
Now you have structured this appeal under what provision?
It is in the
Section 19
Section 9.
Of?
of the Family Court.
How is it, how does the family court,
My lord.
what is the application of the family court act?
Civil code is also, my lord, one family code as per the Family Court Act. And against the interlocutory order, my lord, appeal is maintainable. One. It is, in fact, it's not interlocutory because it has already been disposed of.
No, we are not on
And-
the interlocutory part. We are on the application of section 91 of the Family Courts Act.
Yes. Because civil courts, my lord, as per Family Courts Act, my lord, civil court is also deemed to be a family court, while family court is not there. So and same procedure is followed, my lord, on the basis without any.
No, Mr. Roy, you are aware that you need not go to many other aspects.
Yes.
A divorce decree passed by a family court has to be before a division bench. Same divorce decree granted by this district court is before a single bench.
Yes.
Is there any analogy? Nothing, but that is the law.
Yes.
We have to go by the law. How do you bring in section 19?
Well, then it may be converted, my lord,
No,
may be converted to section
converted-
27.
Whether that permission will be that conversion is possible as of today, my lord, because he has to file a fresh. Because this appeal
this
is
is not
maintainable neither under section
maintainable.
19 nor under section 28 of the ATMA, my lord.
No, Hindu
Yes,
Marriage
no,
Act.
sir.
The substantial act, not the procedural act of family code. The Hindu Marriage Act itself grants you a provision to prefer an appeal.
Yes, my lord, Your lordship, please, that judgment. So it is
28,
Yes, 28.
all decrees made by the court in any proceeding under this act shall, subject to the provision of so and so, be appealable as decrees of the court so and so. Orders made by a court in any proceeding under this act, under section so and so and so and so.
So 25 and 26.
25 and
not
26,
24.
not 24.
That is excluded. He has to come under 227 only, ma'am.
Yes, my lord, that one thing, my lord, I have one judgment, division bench judgment, that's your lordship. That is also against the order against section 24.
No, the learned court
Yes.
by which had considered this matter had not even gone to the aspect of the applicability, not of section 19, of the applicability of the Family Courts Act itself. The argument was that 19 is not applicable.
Okay.
And court says no, 19 would be applicable. But when there is a substantive provision in this act of appeal, that's another matter whether it comes within the strict ambit of 28 or not. If not, you have remedies in law, 227 is there.
Then, my lord.
Yes, on the merits, what, anything you would
On
like
the
to
merits
say?
for the Lord people, see that the learned trial court has come passed a very reasonable order, 15,000 in this day and age. And my lord, he has indulged in absolute separation. Lord people kindly come to my written objection in the main, the.
And no separate maintenance for the son.
No.
15 will cover everything.
15,000 for both. And Lordship, he has annexed his father's Jamabandi of the year 1999, a handwritten Jamabandi. I have annexed the latest Jamabandi. His father has 3 plots, my lord, in the Hojai town itself.
Yep.
They are dealing, please don't interrupt. Look, here they are dealing in the cloth business.
What
And
business?
Cloth.
Cloth.
Wholesale merchant of
Oh.
cloth. And my lord, he has deliberately suppressed by
No, cloth
filing.
business, Mr. Ray has
He is
told.
saying I sit in the heart. But
Heart.
whereas, my lord, they are having shop in the heart of the town. His father has 3 plots, my lord. It is clear from the Jamabandi latest, my lord, which I have
No,
annexed.
plots are different. How many shops do they have?
No, my lord, not different. The issue is that he is saying I am supporting my old father and mother. He has a brother also. His father has 3 plots of land. His father has separate
No,
business.
plots will not bring money unless that's given for business.
Fine, my lord.
You may have
My lord,
plots of land.
Why did he file the Jamabandi of 1999 when the latest Jamabandi is available on the
No,
directory, my lord?
are you contending that in those plots, some activities are going on, income is being earned?
I am saying, my lord, that his business is separate to that of his father. His father has separate business. He has separate business. He surely has enough financial capacity, my lord, to pay 15,000 a month.
And the parents are not dependent on
Parents
his
are not dependent on him, and they are.
That is
he
your
having a
stand.
brother also.
That may be your stand, that the
Right.
projection is
No,
trying
sir,
to make.
The intention has to be seen. Why did he file the handwritten Jamabandi of 1999, my lord? Is this not suppression, my lord, writ large, my lord? When the latest is available, I have annexed the latest. Why to indulge in this suppression? And he has not paid a fine for the son.
He is
since
not an
2020.
up-to-date person. He is not technically savvy as you are. He believes in handwritten Jamabandi.
Look, Lordship will also consider another aspect of the matter, that my lord, the income of the parents of the wife, Lordship, the Supreme Court has
Your
held-
parents.
Yes, that is not material for deciding an
That is not
application.
material.
Manish Jain versus the Akanta Jain judgment is there. I
That
can
is not material.
provide you, Lordship.
You are not dependent on your parents.
Yes, the core issue is, my lord, that he, my lord, is staying in Hojai. He is having a business. He is not even ready to pay, and he has not even paid a pie for even the son also since 2020. He has not denied the paternity of the child. My lord, people consider in what circumstances, my lord, these daughters are. My lord, if he wants to still assail this appeal, he can withdraw and he can file a fresh if he wants. Because this is not maintainable. I have 8 judgments of different high court. My lord. This appeal is not
You are on
maintainable.
slippery ground, Mr. Rai.
My lord, what happened? Before filing this divorce, she has not filed any maintenance case. That means she was maintaining, my lord.
We'll
she-
not go to the
Well,
assumption that once
yes.
since you are not filed,
Yes,
then you are precluded from filing at a later
no,
point
I
of
am not
time.
going to, but that means, but one thing, my lord, my father's income he is counting, but that will not come. And my income will be my lord counted, and 3 years as per relevant provisions, I have 3 years income tax documents I have submitted.
No,
out
that is all okay, but you have projected that out of this 30,000 which you are
Yes.
showing to be your income, you are also maintaining your old
Yes,
parents.
that is
That
I-
is your stand.
Yes.
Mr. Ganguly is trying to show that you have a separate business. Your father has separate business.
Father's income, my
Father
lord.
parents are not dependent on you.
Yes, but he cannot show, my lord, my father is earning now. He had a business. I have also submitted that he had a business, but now he cannot, my lord, do that.
What is the age of your father?
My lord, 67 years. So, and some ailments is also there. My mother's also has some ailments. Moreover, I am agreed to bear their cost. But the amount, that quantum is heavy on me. Then I have to live one side. That is the submission. On the basis of my lord income, it may be settled.
15,000 is not for your son and the wife.
Yes. Then, my lord, something, my lord.
But you have to rectify first the
Yes.
procedural aspects. What will you do? Withdraw this? You take instructions, will not pass any orders without, you take instructions. Convey your client that this is not the way. Or if you want, you can withdraw, we'll give you liberty. You can also direct return of the certified copy.
Okay.
As per,
To remove, yes, as your lordship.
no, you say, it should come from you. We can direct the registry to return you the certified copy also.
Then, okay, I am withdrawing and file.
Okay. Heard Sri A.K. Rai, Learned Counsel for the appellant. Also heard Sri Ganguly, A. Ganguly, Learned Counsel for the respondent. Full stop. The appeal has been preferred under section 19(1) of the Family Courts Act 1984. Full stop. Sri Ganguly has, however, pointed out that the order impugned, firstly, is not passed by a family court, and therefore, the very application of the Family Courts Act 1984 is erroneous. Full stop. Secondly, he submits that even under the Hindu Marriage Act, it would be debatable whether an appeal would be maintainable, as the appeal is against an order which is not under section 25 or 26, which are the only two provisions mentioned in section 28 of the Hindu Marriage Act, providing for appeal against decrees and orders. Full stop. Para. Sri Rai, the Learned Counsel, at this stage, praised for allowing him to withdraw this appeal and file and take the appropriate course of law according to law, course of law as permitted. Full stop. Para. Considering the above submission, the appeal is dismissed on withdrawal. Full stop. With liberty. Full stop. Para. Further, this court directs the registry to return the certified copy of the order dated of the impugned order dated 3/2/2024 to enable the Learned Counsel to approach to assail the order in the manner prescribed by law. LCR had come.
No.
So we'll retain the LCR for the time being.
That can be done.
Huh? How soon can you prefer this revision or whatever?
Time frame,
Huh?
my lord, that you are-
You can go
Because
for
otherwise
it.
the LCR will be, if the LCR is here, my lord, I cannot execute the meeting. That is the difficulty. Or my lord, the LCR can be sent back, the revisional court can call for the scan copy also, not necessarily.
Let the LCR be returned back immediately. Huh? I was for what?
I was for stay, my lord.
I,
Only
that is
local,
for-
so-
I,
As per office note dated 6/6, my lord, the respondent number 1 and 2, my lord, received the notice and appeared. And in case of
Mr.
respondent number,
Mukherjee, you are for 1 and 2.
respondent number 3, my lord, also received that notice, my lord, he did not appear.
You are on the IA.
I am a lot of stay of the order. Injunction order.
The appeal has been admitted.
No, my lord.
Appeal has been admitted.
Yes, my lord.
There are only 3 respondents.
My lord, 3 respondents.
Third has also received notice by one of the staff in the office.
My
So it is complete. What is the order passed in the stay application?
My lord.
What is the order passed in the stay application? No
My
order.
lord,
Any order passed in the stay application?
no, order passed.
Receive a copy of the stay. Don't have a copy of that.
You serve a copy?
My lord.
Okay.
And
Three.
scan copy of LCR has not received, my lord. As per office note. Remainder may be issued, my lord.
Let a copy of the stay application be served upon Sri BJ Mukherjee, learned counsel for the respondent numbers 1 and 2. List immediately after the vacation, along with. No. In view of the office note dated. पहला वाला रहेगा, हाँ? In view of the office note dated 6/6/2024, registry is directed to issue reminder for the LCR. Full stop. List immediately after the vacation, along with report on the LCR. Stay वाला रहेगा, हाँ? Stay का petition.
Item 30.
30.
May it please your lord. Lordship, the present review petition is filed with a very limited prayer, as there was no observation in connection with the petitioner number 1, where she received the Ziraat amount also and the notice for submission of document, everything also. But there was no mention about that disposal of her claim, whether she is entitled for the land amount or not. They are not doing anything, your lordship. It's been 2 years.
Wait, please, the lordship. Lordship, I would like to take instruction, lordship, if it has been,
Is it listed for the first time?
Yes, sir.
yes, lordship.
Last time it was listed, but due to paucity of time, matter could not be taken.
Lordship, if it has been
But
complied or
very
not,
limited prayer, your lordship.
if it
Very
has been
limited prayer.
complied or not, I would like to take instruction on that, lordship, and they have filed contempt petition also, lordship.
That was
Earlier, which
withdrawn.
was withdrawn and it has been closed. So I would like to take instruction.
Okay, you take instructions.
Yes,
We'll
sir.
have it on the reopening.
Lord.
First day of the reopening.
Sure.
Okay. Your KJN,
Yes, sir.
heard Miss KJN, learned counsel for the review applicant. Para. Miss
Escape.
S. Kemprai, learned standing counsel.
4 to 9.
KAC. Praise for and is granted time to seek instructions. Madam, you are for AG. NHIDCL. इनका नाम लिखिए. And Mr. Gogoi for Miss, your name, madam? Tinglu. Miss Tinglu, learned counsel is present for the NHIDCL and Sri T.R. Gogoi, learned state council is also present. Okay. List on, list bola kya? Right. List on 17th of July.
DP of
Item 31.
Mr. Padgiri, what is this?
Kindly peruse the order that office note dated 14/6, my lord. The daughter of the sole respondent received the staff notice, but she has not appeared. The IA is for condonation of delay of 31 days, my lord, for preparing the matrimonial appeal.
Your daughter is staying with the mother.
My lord.
Part 3 K.R. Padgiri. For the applicant who has referred to the office note dated 14/6/2024, as per which the notice upon the sole respondent has been received by her daughter, by the daughter, full stop. The connected appeal arises out of the judgment and decree
My lord, judgment and decree.
in a divorce proceeding. Divorce proceeding.
My lord, divorce proceeding.
Puts the para. Be that as it may, be that it may, and in the interest of justice, a further opportunity is granted to the respondent to make appearance, fixing the next date as 15th of July,
Hello.
2024, full stop. On the same date, however, this court would proceed with the consideration of the IA.
My lord.
Let there be another chance. If they
My lord.
come, well and good. If they do not, also we'll go ahead.
Obliging.
Item 22.
The Bansky matter.
Lordship, earlier order passed by this honorable court. That's why.
I have received for?
For it is for correction of some course title. Lordship, kindly take the writ petition. I think it is a bona fide mistake, Lordship.
Where?
Lordship.
Correction order, Mr. Gogo will do it. If it's, if he makes out a case. Which page?
Lordship, page 14.
1-4.
Lordship.
Yes.
Lordship, serial number 7. Lordship. Shaidul Islam Lordship. His name to be Shaidul Alam Lordship.
And father?
And father name Lordship Moinuddin Lordship. That is correct. His address is something different, Lordship. It is Rangpur, Part 4.
We considered this matter on the last occasion.
Lordship.
Somebody files a case, somebody else tries to take a benefit.
Lordship, that is, I think it is not in this case. Lordship, kindly look at the writ petition, annex to the writ.
No, not your annexure. You had, these are the addresses which you had given in your cost title. These are not typed by the court.
Lordship, it is our fault. Lordship, actually our typographic error. Lordship, document that we annex to the writ petition reflect that he is a resident of Berenga
And
Lordship.
what is the other,
Both the
what is the other error? Only this one?
Lordship, another
You- where-
Abul Hussain is Abdul Hussain,
Number 7.
Lordship, number 7. And his father's title was not there,
We have considered this matter last occasion.
Lordship.
When I tried to mention during the rising of the court.
Lord.
Mr. Gogoi,
Lordship.
what is the document regarding 7?
Lordship, his school certificate and application result of the Lordship.
Part 3 L.R. Mazumdar Learned Counsel for the applicant. As well as 3 T.R. Gogoi Learned State Council, full stop para. By the present application, comma, the applicants have prayed for certain prayed for correction of certain errors in the cost title. Number 3 cutoff, strike off means?
Lordship.
Why do you strike off the name of number 3?
Lordship, he is not interested. Petitioner number 8 is not interested.
Now, how can you strike off now after judgment has been passed?
That may be, that is not,
Amongst the prayer,
Lordship,
Well,
that
among- amongst the prayer which can be considered, comma, Sri Mazumdar Learned Council has considered amongst the prayers made by the Learned Council which can be considered, comma, the first prayer is with regard to the name and address of the respondent number 4 of the petition number 4 in WPC 5535 of 2022. नहीं वहाँ मत लिखिए टाइपोग्राफिकल और क्या पहले क्या लिखा फर्स्ट टाइटल appearing in the judgment and order dated. Yes, date.
Lordship, it is in the our IA Lordship, page 7, para 2.
Order dated, date
10/5/2024.
10/5/2024, passed in a bunch of writ petitions, including WPC,
Lordship, WBC number 3734, 2022.
37. Why 3734? Sahidul is in 5535.
Lord. And first one is Lordship 3734, 2022.
Page?
Page Lordship 11. A batch of writ petition decided by this common order Lordship.
No, in 3734, which one?
It is Bikash Panya and others not connected.
No.
Our case Lordship page, it is
You
Lordship.
understand, Mr. Mazumdar, very confusing.
Lordship,
Passed in a
it is
bunch,
page 14.
bunch of writ petition, including WPC 5535 of 2022.
Right.
Amongst the, huh? With the name of the main name and the address of the petition number 4. Full stop. It is submitted that in the cost title, the following was stated. यहाँ पे 14 में इसे पूरा लिख दीजिए हाँ साहिदुल इस्लाम लश्कर एकदम पूरा एकदम यहाँ तक. It is clarified that the name of the petition number 4 in the said WPC 5535 of 2022 should be
Shahidul Alam Lord.
Sahidul Alam, ALM.
Lord.
ALM हो जाएगा. And others?
Other Lordship, he is resident of Berenga.
Resident of?
Berenga.
Village?
Village Lordship Berenga.
Where have you stated?
Lordship, I have stated in page 7, para 2. Berenga part 5, Yo Betukandi. Yes.
Our Berenga, huh? Yeah.
think so.
Yeah. Similarly, for petition number 7, which was stated as, पूरा लिख दीजिए, 7. Similarly, the name of the petitioner 7 was written as so and so. It is submitted that the corrected name and address would be Abul, huh?
Lordship.
Abul Hussain.
Abul Hussain Majumdar,
Son of-
son of Ilyas Ali Majumdar.
पैरा दोनों चार होगा ना Three, the learned council has submitted that the error had crept in. An error was an inadvertent one, which had crept in the writ petition during his presentation. Full stop. He has also submitted that the connected documents were already filed with the writ petitions. Full stop. Para. Sri T. R. Gogoi, Learned Council, State Council submits that he would not have serious objection in principle on the prayers made. Full stop. Para. Considering that the error pointed out while presenting the petition and which eventually was a part of the connected order dated 10/5/2024, comma, this court, comma, in the interest of justice, allows this petition by observing that the correct name and address of the respondent of the petition numbers 4 and 7 as reflected above are to be taken into consideration. Full stop. Para. Let this order be read as a part of the order dated 10/5/2024 passed in the bunch of writ petitions, including 5535 of 2022. I stand disposed of.
Obliged.
Item 33.
But the prayer in this IA is to return the statutory amount received along with interest.
Interest.
Yes. Interest is payable, Lordship. I think have received some order.
The matter has been disposed of.
Yes, Lord.
Where is it deposited? Registry of this court.
But the deposit, Lordship, I am not, I have no interest. But case is disposed of in 2020.
Huh? Case was disposed of when?
5/10/23.
Heard Sri A.J. Saikya, Learned Counsel for the applicant insurance company. Full stop. The applicant by this application has prayed for refund of the statutory amount of rupees 25,000, which was deposited at the time of referring of the appeal. Full stop. It is submitted that the appeal was disposed of on 5/10/2023, when, however, there was no mention for return of the statutory amount. Full stop. Where do you get interest?
Yes, Lordship, it's interest we are getting.
Okay.
Some different are also here, Lordship.
Okay. Sri Saikya, the Learned Council also prays for a direction to pay the interest accrued upon the said amount.
Yes.
Puts the para. After consideration of the submissions, comma, the instant IA is allowed by directing refund of the statutory deposit of rupees 25,000 made by the applicant insurance company in connection with filing of MSC appeal 337 of 2021, which was disposed of on 5/10/2023. Full stop. The interest which have accrued upon the amount is also to be paid to the applicant. Full stop. How will it be paid?
Lordship, registry will write to the bank, bank will calculate and accordingly.
The registry is accordingly directed to take necessary steps for refund of the amount in the manner indicated above. I stand allowed.
Item 54.
Anybody?
Yes. Lordship, here I have filed this IA for modification of the last order. Order dated 28/3/23 passed by this honorable court, Lord.
Date?
In fact, it is a joint here, your lordship. The affidavit is shown by all the parties.
Where page?
The order is at page 22. Connected.
Yes, what is the
What has
order?
happened, your lordship? In this order, your lordship, it was prayed that the case may be withdrawn and it was allowed, it was withdrawn, your lordship, in view of a compromise. The only difficulty here is, your lordship, there was a compromise decree, there was a compromise document, your lordship, that was placed before the court, and that was not recorded in the order, your lordship. In pursuance to that, these parties are facing difficulty that they cannot proceed with the order, your lordship, for mutation and other purposes of the, as that portion of the compromise was not recorded, it was withdrawn quickly. Due to inadvertence and
The compromise deed has to be made part of the decree.
that was not produced to the decree, not produced. Even the records also doesn't have that.
No, did you did you present a memorandum of compromise?
That was shown to the court, but that was not kept as a part of the record as well.
Where is it?
Now
Because we have annexed it in this IA here.
IA, Lordship will find it page 9.
Yes, what do you suggest then?
Lordship, in page 19 is the schedule that they have agreed to settle within themselves. Schedule A is the main property, page 19, entire property. That is apportioned between the parties as schedule B.
What is this rectification?
There were certain changes in the dark numbers and the person numbers in the compromise. So for that reason, a rectification deed was between both the parties.
There was in the schedule A, there was some incorrect.
The tag number and button number was not correct.
In the other schedule, it was okay.
In all the three, look at page 18. It says in page 3, 4, and 5 of the principal deed, page 18. Actually, the old tag number and button number were typed out in the previous deed. They corrected by.
Let this go before the appropriate bench. Is that bench available?
No,
Not available.
at this moment it is not available.
Hey, Nandi madam কেতিয়া বহিব? Nandi madam আছে নেকি? What do you want to incorporate in this?
Lordship, if the portion mentioned in page 19, your lordship, is reflected in the order that will serve the
19.
page 19. Schedule B belongs to the petitioner number one.
No,
and
we can, see that degree, that compromise deed, originally is not before us. It is, we can do one thing. We can, direct you, both of you, to
produce the-
approach the, court where, by which the decree would be executed. And we say that you, both of you present that, original memorandum of agreement. And in terms of the observation made by this court on 28/3/2022, let a compromise deed be prepared, and you go for execution. I think that would be the best.
Yeah.
Instead of we exercising that powers,
Yeah.
okay? This is item number
34.
30.
34.
What is your name?
A Decalo.
No, where is your name?
What should be actually the council was N Chaudhary. I am appearing for N Chaudhary Lordship.
You should be there, your name should be there.
So Lordship is on text. So for that reason,
These are matters where you are paying for some out of Part 3 A Decca Learned Council appearing on instruction of the applicant. This is not a joint application,
The affidavit shown as a joint.
but no, not joint application. By the applicant. Also heard Sri B.J. Mukherjee, Learned Counsel for the opposite party. Full stop. The application has been filed for clarification of the order dated 28/3/2023, passed in the connected MFA 80 of 2014. MFA was against what?
Judgment and order dated 7/5.
Of
District Judge Bongaigaon
regarding?
regarding a letter of administration proceeding, but it was dismissed.
Okay, or letter of administration,
Yeah.
okay. It is submitted that the matter was settled outside the court. And in that regard, a deed of memorandum of understanding, cum agreement, was also registered on 3/2/2023. Full stop. It is also submitted that while the order dated 28/3/2023 of this court has recorded the aforesaid fact, comma, the deed as such, the deed as such or any of the details have not been mentioned in the order, as a result of which the parties are having difficulties in executing the decree. Full stop. Para. Sri B.J. Mukherjee, Learned Counsel, submits that there is no objection at all, and in fact, the affidavit supporting the present petition is also executed by his client. Full stop. Para. After considering the submissions, comma, this court is of the opinion that instead of clarifying, instead of clarifying, and instead of making any clarification in the aforesaid order, comma, the parties are directed to present the copy, the registered deed number 215 dated 3/2/2023 before the executing court, before the executing court, along with a copy of the order passed today. Full stop. The learned executing court is accordingly required to take into consideration the aforesaid deed as the same is the deed of compromise, and it is not the executing court, it is the first court,
Original jurisdiction, court of the origin.
a court of the original jurisdiction. What was the court?
District Judge Bongaigaon.
District Judge Bongaigaon, submit district, is accordingly directed to draw up a decree in accordance with the compromise deed dated 3/2/2023, whereafter the parties would be free to execute the same in accordance with law.
The compromise deed and as well as the rectification.
Compromise as well as and rectification, don't like this. Huh? I disposed of.
May I please?
Yes, Mr. Islam.
There is a delay of 49 days preparing the connected MFA.
First time.
First time it is.
Okay. But Sri S. Islam Learned Council for the applicant who by means of this application filed under section 5 of the Limitation Act has prayed for condonation of delay of 49 days in preferring the connected MFA full stop para. Let notice be issued, returnable by 6 weeks. Let steps be taken for service of notice upon the opposite parties by registered post with AD, steps within 2 days. Okay.
Item 26.
Here in this case, Lordship, I am praying for a direction to the opposite party to deposit at least 50% of the awarded amount. And of deposition same, the claimant may be allowed to.
The amount, awarded amount is 14 lakh something, my lord. So, my lord, 20% or 35%.
Lordship, their main ground is that since both the vehicles are involved, they are not liable to pay the entire amount. 50%.
How much is the amount? 14 lakhs.
Yes, my lord.
The entire amount has been settled upon you.
Lordship.
Madam,
Yes.
entire amount has been settled upon you.
Yes, 14 lakh 78,000.
Huh?
14 lakh
So
78,000.
you contend that it may be, if contributing negligence would come in, it will be 50%.
Lordship.
So you pay 50% now?
50%.
Your interest would still be protected.
Interest.
Interest is there, 8%.
Interest.
No, your interest,
Lordship.
not amount of interest, your interest
Yes, no.
will still be protected. Heard Sri M.
And
Talukdar, Learned Council for the applicant. First of also heard Miss A. Gayan, Learned Council for the opposite parties 1 and 2.
1 and 2.
Full stop. It transpires that the opposite parties 1 and 2 had filed MSC appeal number 160 of 2024 in this court against a judgment and order dated 5/12/2019 passed by the learned MACT Karbi Anglong in MSC case number 1 of 2019.
18.
Huh?
1 of 2018.
18, full stop. The aforesaid appeal has been admitted on 13/5/2024. Full stop. Para, Mr. Sri Talukdar, the Learned Council for the applicant has submitted that 50%, at least 50% of the awarded amount may be directed to be paid. Full stop. May be directed to be deposited with a further direction that the same be released to the claimant. Full stop. Para. Ms. Gayan, the Learned CGC, however, submits that there are good grounds in the appeal which is likely to succeed. Full stop. she has also submitted that two vehicles were involved and the entire liability has been saddled with the opposite party numbers 1 and 2, full stop para. Be that as it may, comma, this court is of the opinion that interest of justice would be served if 50% of the awarded amount is directed to be deposited in this court. Full stop para. Accordingly, the opposite parties 1 and 2 who are the appellants are directed to deposit 50% of the awarded amount in the registry of this court within a period of 45 days from today, full stop. On such deposit, comma, the claimant would be entitled. What was there any structure in the award?
No.
Entire amount directly pay?
Yes.
Or was there any for FD or anything like
No.
that? The last listen. Entitled for release of the same on being properly identified by the learned counsel and upon furnishing a bond. You furnish a bond.
Obliged.
Appeal is already admitted, and during issuing notice, we came to know that respondent number 2 has died during the time of trial. So at this stage, we are filing appeal with a petition for condonation of delay as well as substitution and cancellation of it.
No, but you said appeal is already admitted.
Appeal is already admitted, but the respondent number 2 has died, and we have to substitute the legal heirs.
No,
But he
you
died at the
said
time
that
of
he died at the time of trial.
trial.
No, you cannot substitute, you have to add.
Actually ends.
You have to add. You have to file an order 1 rule 10. You file it. Okay. Because substitution would come only a pending proceeding.
Pending.
There is no pending proceeding. At the time when you instituted this appeal, there was no, the person had already passed away.
Already passed.
Sri S.K. Goswami. No, how Sri S.K. Goswami, learned counsel for the appellant who submits that subsequent to the filing of this appeal, comma, it came to be learned.
After issuing notice.
It came to be learned that the respondent number 2 had passed away even during the
Stage of trial.
stage of trial. Full stop. Para. The learned counsel accordingly prays for and is granted 4 weeks' time to take appropriate steps for implementing the legal errors of the said respondent number 2 by filing appropriate application for implement. Full stop. Just after 4 weeks. Yes.
I know this is an application for continuation of delay of 95 days, Lord, in preferring the appeal. It is for the first time.
Okay. Heard Ms. M. Chaudhary, learned counsel for the applicant who by means of this application filed under section 5 of the Limitation Act 1963 has prayed for condonation of delay of 96 days in preferring the connected appeal against judgment dated 2/1/2024 passed by the learned Commissioner, Workmen's Compensation, Bongaigaon in WC case number 23 of 2019. Para, let notice be issued. Returnable by 6 weeks. Para, let steps be taken for service of notice upon the respondents 1 and 2 were registered post with AD. Steps within 2 days. It was IS 1799 at home. Item 29.
Lordship, is an eye for condemnation of delay, Your Lordship, 30 days. Yes.
Your name?
I am FN Jaman on behalf.
FN Zaman.
Yes, Your Lordship, on behalf of S. Roy.
Asra, FN Zaman কি হবো হ্যাঁ খালি এতে 30 days হবো আৰু judgment and award হল 17/1/2024 MAC 1407 of 2018 passed by Learned MACT number 1 comma Kamrup within bracket M. ঠিক আছে notice. Take steps, madam, by registered post with AD. 6/6 returnable.
Apply.
48.
Look, it's the IF for condemnation of delay, my lord, in filing the testamentary appeal.
First time?
First time, my lord. 817 days,
Only?
my lord.
What were you doing 800 days?
My lord, he was suffering from neurological disorder, my lord. I have annexed some medical
How many days?
My lord, document is for, my lord, he was under treatment since 2020, my lord.
Now you're
He
okay.
was unable to move, my lord, without help of others.
NK Kolita, huh? To celebrate. Judgment and order written 9/12/19 passed by so and so and so and so. ঠিক আছে? Day whole 817 days. Notice whole. Who are the performer respondents?
My lord, they were the defendant in the, my lord, earlier case. Earlier.
Oh, you say you take steps on all.
My lord.
All the respondents, huh? 6 weeks. 2 days. Registered post AD. We're making returnable 6 weeks.
My lord.
41.
Delay convention petition of 49 days.
39 days. Ages IKEA. 49 days delay. Judgment and order side about it. Workman compensation. Also. Take registered steps within 2 days. 6 weeks returnable.
Made this law. Delay of 2,738 days.
2000.
Well, in fact, delay of 41 days. What happened, my lord? We filed
2000.
We filed appeal in 2014 itself. After that, my lord, our clerk, there was some defect in the, my lord, the appeal. Then the clerk has taken back the file, and we have rectified that. Then we have given it back to filing to the for the filing before the registry. What he did, my lord, we could come to know that he has left his work, his Jadhav Podo, I have named also, and he did not return to the registry. And after an inquiry, my lord, and this case was never listed also. In the meantime,
So you
my
never
lord,
inquired why the case was not listed?
we made an inquiry, then we came to know.
No, when did you make the inquiry? After 2000 days?
When the insurance company informed us that the position of this case we are yet to know. Then we made an inquiry, and then, my lord, we came to know that this file has not been returned. And we, my lord, contacted the registry. Registry said you filed, we requested for reconstruction of the brief. Otherwise, delay will be abnormal. But then registry said, no, you file a new application. And at that circumstance, my lord, we are before lord. Now, delay is, my lord, huge. In the meantime, execution started. Lord, if I am within my limitation, can I pray that your lordship issue a notice, and in the meantime, entire amount will be depositing before this registry, my lord.
Amount in what? MSCT?
MS.
How much?
This is the 13 lakhs and odd.
For death?
Yes.
Who, this is was what?
This was, my lord. This is one. This is, appeal to this. My lord, he was doing business. He was traveling in a as a gratuitous passenger in a pickup van. That is the legal question which will involve.
What is the business he was doing?
These are not narrated that way, my lord.
What are your grounds?
Ground is the
Registered passenger.
My lord, in order to, my lord, because once execution starts, the next phase will be the issuance of warrant and all that. So if your lordship passes an order, that entire amount will be deposited here before the registry. And execution, if your lordship, so we.
No, we do not delay condemnation, we will not say anything.
That I am aware, but then, my lord, the peculiar fact of the case is like that. In fact, my lord, we are also not at fault.
R3 as Dr. London Senior Counsel, assisted by S. Musari. I do. Section 5. For delay of 2738 days.
Yes.
In preferring, so filable. Para. As noted above, the delay is huge. Full stop para. Nonetheless, let notice be issued. Returnable by 6 weeks. Steps, where is that posted AD? Steps within 3 days.
Ma'am. Obliged.
Wait, the lordship listed for the first time, there is a delay of years.
RD Mazumdar, MSc?
MSc lordship,
How many days?
95 days. sir.
95 days. Filable. Yes, you take steps within 2 days.
Yes, sir.
Registered posted AD 6 weeks returnable.
Highly obliged.
Item 44. Lordship. This thing is pending for service report, madam, for last 3 years, madam. But already always the notice is served, but the report is not received by the equipment. Madam, this time I have collected service report from the internet, madam.
You have not taken dusty service. You have not taken dusty service.
Yes, sir.
Dusty.
First time assessment, it was sent to go PGM, but a report has not yet arrived. Once it came a lot about 1 year ago, and that case was dismissed for my default. I could not appear. I was late for 2 minutes.
No, that is
I can
okay.
give it
That is okay. That is okay. No, you're also directed to send, take steps by Dusty. Take steps by Dusty service.
Yes, sir.
You have not taken. Take it.
No, I have taken, madam.
Dusty service.
Yes, ma'am.
Where? Where is the affidavit? Affidavit of Dusty?
Justice Service Manager, I have forwarded it to PGM, my lord.
You cannot. Dusty is not by CGM. Dusty is not by CGM. Dusty is personal service. You take the notice from the registry, serve it yourself, or through your agents, not through a court or anybody. And file an affidavit, whether he has accepted, not accepted, you can state everything in the affidavit. But we wanted whether you had tendered the notice. Thereafter, if it is not even accepted, you can state it in the affidavit. We will accept it. That is the reason why affidavit is received.
Sorry, mother. I thought that Justice Service means.
No, Dusty. It appears that steps by Dusty Service has not been taken, and in this connection, office note dated 12/6/2024 can also be seen. Full stop. Para. Sri B.C. Das Learned Counsel prays for another opportunity to take steps by Dusty Service upon this whole.
One service notice has been filed, my lord.
No, this is not, this you have to give an affidavit, or this will have to go to the Lazima. We cannot take cognizance of this in absence of an
He
affidavit.
received it on personally, madam. It is.
No, you take dusty service. That was the order of the court.
The justice service means I have to go and for the site.
Not you personally. Your client may go, his agents may go, his family member may go. But somebody needs to go and serve. Where is the respondent? Which place?
My lord, my client is staying at Vishwanath Sareli, about so many kilometers away, my lord, and the respondent remain is at about 150 kilometers.
Where?
He is the lady, my lord.
Where?
Jamuguri, and another is Jale.
No, but you did not say anything when dusty service was directed.
By justice service, I mean, my lord, that it will be through a court, and court has.
Halem.
Once, about 1 year ago, it was served, my lord.
From Halem to Biswana, Jamuguri, how far it is? How from Halem to Jamuguri?
I'm not followed on that.
From Halem to Jamuguri, what is the distance?
Jamuguri, it will be about 150 kilometers, my lord. Up to Tezpur is 105 kilometers from her house.
No, your place is at Halem.
Yes, my lord.
In the district of Biswanath.
My village is, my lord, Sanmari.
No, you have to serve. You can send somebody, the lady did not go herself. She can send anybody. We'll give you time. Okay, cool. Agorkhani question, no? Upon the sole respondent, full stop. Para. Let another chance be given to serve the sole respondent by dusty, which is to be routed through the registry of this court, and in the notice accompanying the dusty, the next date is to be clearly reflected, full stop. Fix the, let the next date be fixed on 24th of July 2024. Prior to the next date, the petitioner is also required to file an affidavit in proof of such dusty service. You take steps immediately. Give a copy of the petition to the registry. They will prepare the notice. You know what to do. And send it to your client to serve upon the respondent. Yes, next.
Item 45.
May please, Your Lordship.
Mr. Sharma, what is this?
This has come for the first time after notice. They have entered appearance.
You have entered appearance.
My lord, on behalf of all the.
It's a CRP.
CRP.
For?
This is against rejection of an order. We had filed an application for scientific investigation of the signature, which was rejected. Order 20.
Okay.
My lord, the petitioners are substituted on the death of the original plaintiff. The original plaintiff never raised this question. My lord, no claim has been filed earlier.
Now we'll hear this whenever you're ready.
My lord, before vacation, my lord. They are trying to, my lord, change the entire structure, my lord.
No.
This
was which structure?
My lord, there is a house and they are reconstructing the house, my lord. There is an order preventing them to make any construction, my lord.
That's a different matter. You file an application. Mr. Sharma, don't change the nature and character of the suit land.
Yes, I say, Your Lordship, I am not aware of it. However, I will advise my client. And if
since it is come from Mr.
Yes,
Sikdar,
I will ask.
There is an order of the court.
He will not make submissions in the air.
Yes,
He must have been instructed.
Advise my client.
Okay. When?
My lord,
after
before
vacation, not possible. We'll have it. I will fix a date on 17th July.
Can it be?
You are reopening on
19th.
Yes. Okay, 19th.
My lord,
Okay.
my lord, may I pray for my lord directing my lord to maintain the status of the property.
We'll record his submission. Third, Sri R. Sharma, Learned Counsel, for the petitioners. Full stop. Para. Pursuant to the notice issued on 9/2/2024, Sri A. R. Sikdar, Learned Counsel, has entered appearance for the respondents. Full stop. Para. Sri Sikdar has, however, informed that the petitioners are making constructions, are changing the nature and character of the suit land, full stop, para. While fixing this matter, and let the matter be fixed for consideration on 19th of July 2024, full stop. Sri Sharma, the learned counsel for the petitioners, has undertaken that no activities would be done by his clients in violation of any law holding the field.
But your lordship, if I may just say, this was just an eviction suit
By
by them. So it is nothing to do with, so this order, I don't know, I have not seen whether a status quo order was passed by the trial court.
no, that is why we have said, we have added, which is violated by, which is not in accordance with law, not prohibited by.
Yes. No, sir.
Okay.